Matter, similar matter has been disposed of. No.
The matter of petitions matter disposed of in earlier occasion by the lordship.
Yes.
That is with regards to the wages matter.
Right.
And this is with regards to the regulation or order passed matter in the year 2000 matter by the land tribunal matter. Despite the orders matter, they have not carried out. They have disengaged. In the way matter, there is an order matter in 2000. That order was also appealed in the 2019 matter by the Sonal Court matter. Despite the orders matter, they did regularize the petitioner. In the meantime, it's attended the matter 61 after that disposal of that order matter, that case matter.
Issue emergent notice returnable within 4 weeks. Who accepts notice? For OP1, who is OP1? So, are you CGC? Yes. Let CGC sign so on our request to accept notice for all OPs. Petitioner to serve copies of the petition along with all documents and applications, if any, right now. First, if service is made, call this matter after vacation. Okay. You copy.
Today,
Item 2.
Yes.
Item 2, WBC 7539 of 2026.
Yes.
Petitioner is very limited.
No, not audible.
The evidences of the petitioner is very limited to the extent that the petitioner has already approached to the DRT by filing the
Essay number 40 of 25 to be disposed of expedition.
that is will be the stipulated type that is.
Short grievance of the petitioner. Who are you? Debtor?
Milord, I am the debtor and one of the legal heir of the mortgage. The
Mortgager is also debtor.
Milord.
The essential grievance of the petitioner who happens to be mortgagor debtor is against long pendency of essay number 40 of 2025 and also IA number 1123 of 2025 filed therein for restoration of possession. Learned counsel for the petitioner submits and we agree that right to speedy justice avails even in the proceedings that pend before the tribunals, like the DR. Notice to other side is since prayer is innocuous and that they would have opportunity of opposing the matter when taken up by the DRT. First, we also keep open all contentions of the parties. First, in the above circumstances, this petition is disposed of, requesting the DRT to take up the subject essay and also IA, as the case may be, all the IA as the case may be, at the earliest. First, ordered upon.
Stipulated and 2 months because
No, we do not know how many matters are pending. That is
the only time limit is so that
expeditiously, preferably within a period of 6 months.
Milord,
Excluding the adjournment sought for by the petitioner. Okay.
I may be scheduled. I number 1123 place में 1133 because that is
But you have written 1123.
But the page number 7 that is printed 1133
33. 1133.
obliged.
Registry to send a copy of this order to the OPs for their file. First, it is open to the said OPs to seek record of this order. If grounds do exist, therefore, come up. since this matter is disposed of ex parte. Obligatory. This right? Next.
Item 3, WPC 10849 of 2026.
May I please?
Yes.
Sir, here is a government managed cooperative society.
Government managed cooperative.
Cooperative society. By the government, it is it's a sugar factory. Some endeavor employees, without having with a fake certificate, they have been appointed here.
When they were appointed.
Earlier by the earlier management. Now the question is, and there is a vigilance inquiry against them, and management has also objected them, and some of them also dismissed.
Yeah.
Some of them also dismissed. So in that event, my lord, now the present management, they have entered into a tripartite agreement. And by that tripartite agreement, they are going to regularize their service.
Who are you?
I am one of the, we are the directors, the previous directors of the cooperative society.
You make a representation to the higher ups.
No, we have made the
Where is
representation.
the representation? Take up.
And it's just, I'm taking a lordship to Annex 7.
Annexure 7.
It is the director that cooperative society has made a reference initiating the in person. My lord, got it. Verification of certificate of employees in their entry in service in industry and certificate in support of their educational qualification and date of birth. In person to the decision letter 5 taken by resolution number 5 of the committee management, I have prepared the list of some employees as produced by GA department under your directions. Here we submit the same to you and to your end for making verification of their certificate in support of their entry in service and educational qualification and transit the same along with your report to the Register of Cooperative Society Orissa for initiating appropriate action. It may be
They will consider your representation. We direct them to consider your representation. Shorn of textual prayer in the petition, comma, learned counsel for the petitioner submits, and we agree that his client's representation dated 7/5/2020 at Annexure 7
and Annex 11.
Other representation dated 19/9/2025 at Annexure 11. Merit consideration at the hands of the addressees of the said representations in accordance with law. First of all, in the above circumstances, petition is disposed of, directing the jurisdictional authorities to take a call on the subject representations in accordance with law at the earliest, comma, if need be, after giving an opportunity of hearing to the petition. First, all contentions kept upon. Show the name of madam. Next.
Well, Annex 16 that is going to be implemented till then.
Nothing like that. Next.
Item 4, WPC 11246 of 2026.
Directly. It's like, dear my lord, only limited grievances section 14 application on the sufficient is pending before the district magistrate Sundargarh since long, my lord. President.
The short grievance of the petitioner bank is against long pendency of application filed under section 14 of the Surface Act 2002, and therefore he seeks the writ of mandamus for consideration thereof on a war footing. First, petition averments are consistent with the category of decisions of the apex court, and therefore matter needs to be treated favorably only for the limited purpose of seeking early disposal of the subject representation after giving an opportunity of hearing to the stakeholders, if any. First, ordered accordingly, and writ petition is disposed of. First off, time for disposal of the subject application is 8 weeks. Okay, all contentions kept over. Next.
Item 5, WPC 12603.
Registration, last one, this one, that same one. Next.
Item 5,
May I please
WPC
allow-
12603 of 2026.
Sir, my lord, in a e-auction, my lord, conducted by the bank, the petitioner stood at the first bidder and deposited the amount, and a sale certificate by the annexer 1 issued on 4/12/2024.
Now Tahsildar issued 22/12/25.
My lord, now the
That-
Tahsildar, my lord, denied to, your lordship kindly see the Tahsildar order.
What he says,
My lord, he denied on the ground,
what he denies,
denied to mutate the land in favor of the present petition.
mutation of entry.
Yes, ma'am.
No provision. Is there Land Revenue Act in your state? Orissa Land Revenue Act.
Yes, that is there, ma'am.
Yeah, you,
In case of denial, what is the provision in the statute itself?
appeal is not maintainable.
My lord, here, my lord, I am the petitioner challenge the election, my lord. It is because it is arbitrary pass, my lord.
No.
Pass, my lord, the
No,
repeat.
case rejected or allowed, Mr. Lord?
Yes, rejected now.
Case rejected.
Your lordship,
Question of arbitration.
your lordship kindly see the impugned order.
No, against it is appeal. Has he rejected your request for entering your name in
My
the
lord, he did not rejected my application. He rejected the request of the bank
request of the bank for?
for mutation of the land in my favor.
Your name in the record of right,
Yes, ma'am.
which is the auction clause. That is the case.
That is the auction.
Bank is not before us.
No. Bank is not before you.
You are not the applicant before the Tahsildar.
Bank
I am not above.
Then
Yes, ma'am.
How you are agreed by this?
My lord, because the land.
Make an application. If it is rejected, come here. You make an application. We will give liberty.
My lord. That's
Short grievance of the petitioner is against Tahsildar's order dated 22/12/2025, whereby request of the lender agency to mutate the name of the petitioner in the revenue records on account of he being the highest bidder who has bought the property in an auction. First, on being asked, learned counsel for the petitioner very fairly submits that what has been rejected is the request of the bank who sold the property, who caused the auction of the property, security property, and not his own application. First, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to make an appropriate representation to the Tahsildar himself, and the Tahsildar shall consider the same in accordance with law after giving an opportunity of hearing to all the stakeholders. First one, all contentions are kept over. Next,
my lord. Your lordship stipulated period, my lord.
whichever you want, first you make application.
I will make, my lord, within 2 weeks, my lord. Your
If
lordship
application is made,
within 2 weeks.
if an appropriate application is made seeking mutation of entries pursuant to the auction in question, Tahsildar to take a decision thereon within a period of 3 months.
My lord.
Next.
Item
You
6,
show the name of madam in every case. Yes.
item 6, WPC 13417 of 2026.
My lords,
Yes, sir.
lords, in this case, in 2006, my elder brother availed a loan from UCO Bank. Keeping-
2006.
Yes, yeah, in 2006, my elder brother availed a loan from UCO Bank by mortgaging our ancestral properties. When I came to know about it,
2006.
Whether
Whether mortgage is registered,
yes, your lordship.
mortgage date is
It's date, your lordship. It's he availed the loan in 2006 from UCO Bank.
no. Our question is different.
Yes, yes. I
What
was
is the date of the mortgage? It's a registered instrument, document. They should have an opportunity of hearing, whether we give relief or not. They should be heard in the matter. That
The
is
date of-
satisfaction. Yes.
date of sanction of loan is, your lordship, 19/6/2007.
So you're not, you don't want to answer our question. Our question is simple, which a matriculate can understand. When the mortgage deed was registered, call after occasion.
You would have get the certified copy of that registered mortgage.
That's
Then
what.
Sir,
Number one. Number two, whether his father is there,
father is, yes, Your Lordship.
father is also there.
Father and elder brother was loanee and guarantor in this.
Then he becomes under Hanuman Pershwad versus Masumat Babo,
Yes, Your Lordship.
19th century judgment of the Privy Council. Father becomes the Karta. He can dispose of the property. Kutumbasthe Vyavaharike Apatkale. It's what Gautama Sutra says. And the Apex Court has said like that. Then how can we challenge that now?
Your Lordship, in last year when I was thrown out of my house because my brother was unable to repay that loan, we approached the Honorable Court. The Honorable Court, by order dated 20 September 25, directed me to approach the DRT. And it also directed to dispose of the matter within 3 months. 3 months had passed, there was no disposal. There have more than 11 to 15 dates, but there was no disposal. Again, we approached this Honorable Court, and this court, by order dated 17 to 2026, directed DRT to dispose of the matter expeditiously. Now, what has happened? On 9th February 26, there was an auction notice that on 13th of May, the auction will take place. So my prayer is that the stay must
DRT has not disposed of the
No,
matter
Your Lordship.
despite order.
Yes, Your Lordship.
Why?
And that is pending, my lord.
No, why it is pending? When High Court says DRT thinks that it is a super court.
On 27th of 2026, my lord,
Huh.
the PO was on leave and it is fixed to 14th May, my lord, for hearing.
But in the meanwhile, if you auction the property, what should happen?
No, that is, my lord, the annexure 5, you are challenging, my lord. Here is a self-proclamation notice by the recovery officer. Thereafter, cell notice will issue, and that is pursuant to the decree passed in the original application. This is the synchronization proceeding. The essay is pending. Essay number 170 of 2025.
Essay should be, there was a direction by us to dispose of the essay in a time-bound way. That has not been disposed.
And that is pending for 14.5. But now, my lord, the annexure 5, that is self-proclamation notice by the recovery officer, that is only the self-proclamation, it is fixed to 13.5. He may appear and he may also.
What he may do? If sale takes place.
No, Lord. Thereafter, cell notice will issue, and it is pursuant to decree passed by the DRT in the original application.
Unless there is a stay, Your Lordship.
So
But
this order will be effective.
Decree.
Our order will be effective because it is fixed to 14.
14.
And you are going to have it on 13.
And 13 only the self-proclamation is to appear.
Whatever.
Thereafter, the cell notice will issue.
No, you wait till that essay is decided.
Yes, Your Lordship.
Lordship can see the self-proclamation notice by the recovery officer pursuant to decree passed in the original application. And on the self-proclamation notice, my lord, only the proceedings of the sale will be decided, and another date will be 1 month notice will be issued for a sale of the property by the recovery officer. Here is a proceeding under the Surface Act you are challenging.
Then he can appear and object to the
Yes, my lord.
proceedings. Unless you object to that, we'll record his submission. That sale proclamation officer, who is that officer?
Recovery officer.
Recovery officer.
Yes, sir.
He will give opportunity of hearing to him.
Yes.
When our court orders dispose of the matter, why the presiding officer is not taking the matters where at least directions have been issued? Somebody should, your president of the bar should go and tell him. When a High Court orders for early disposal of the matter, you are sleeping over the matter, you get up and decide the matter. Or else High Court will be very angry. It will show its red eye to the concerned officer.
Your Lordship, it was directed by the presiding officer to submit the written note of arguments. We submitted it, but the opposite respondents did not submit.
Now they are saying you will have opportunity of hearing before the recovery officer. You go and object to that.
Your Lordship, even if objection, if this is.
How will you argue? We do not know what he is going to do. Because there is a public money which your father and brother have taken. Father acts as a karta. There is a presumption that every Hindu family is a joint Hindu family. And father is the karta of that.
But the loan must be taken for the necessity of the entire family.
How a bank will inquire into all that?
The burden
You should
lies
go to-
good. They
you
should
object
have.
to that one. Petition prayer seeks. Petition prayer is texted as a first. Learned counsel for the petitioner, drawing our attention to earlier rounds of litigation, now submits that despite direction, the DRT is not deciding essay number
170 of 25.
170 of 2025.
Yes.
And that there is no justification whatsoever for defying the direction. First, on being confronted with the earlier orders, next paragraph. Learned panel counsel appearing for the bank very fairly submits that the borrowers have suffered a decree at the hands of the DRT in OA number
491 2012.
2012, 491 of 2012, and that the decree is being put to enforcement
On 28/12/2019.
in what is that enforcement order proceeding?
That is under the 19 of the Abbreviate Act.
Now, what it is called as?
That is a recovery certificate by the recovery.
It's proceeding, what you have done? Put in
Proclamation under C.
enforcement by initiating certificate proceedings
It's
under section 19 of the
Abbreviate Act. Recovery of debts.
Recovery of debt, etc. Act. And that the petitioner will be given an opportunity of hearing by the recovery officer, and only thereafter a decision would be taken. First off, this appears to be a fair procedure, regardless of non-compliance of our orders for early disposal by the DRT, of petitioner's essay, which aspect we need not deliberate much in view of the fair stand taken by the bank. First. Next part, in the above circumstances and with the above observations, petition is disposed of.
Item 7.
Register to send a copy of this order to the presiding officer of the DRT for needful action.
Item 7. WPC 13622 of 2026.
Yes.
But this is this writ petition against the order of London Central Administrative Tribunal. Lord, 8 applications against the single order was filed. Separate applications were filed. First matter, this matter was placed before the London single member for a disposal, and he has dismissed this application.
Other 7, what happened?
Other 7 were placed before the division bench. That was allowed, and the department has already implemented that order. That order, both the orders I have enclosed, and division bench also taken note of.
Take notice. Issue emergent notice. Why that discrimination?
I'll check it out.
Issue emergent notice. First of Mr. Paddy, on request. Paddy, assisted by learned CGC, Mr. So on request accepts notice for OPs. All OPs. All OPs. First, matter lies in a narrow compass. Therefore, post the same in the 3rd week of July. Okay.
Item 8. WPC 14104 of 2026.
Also,
Yes.
pass. Any urgency?
Item number 9. contempt 2731 of 2026.
Judgment of this Honorable Court at 25th of February 2026, my lord. The operating part, my lord, page 19, my lord.
My lord, if the
Page 20.
first time being content has been filed, I'll take instruction, and the similar matters are also pending a writ appeal in the weekly list also this present week.
This is a division bench order.
This is a division bench order of my lords.
State of
This is on 25/2/2026.
Issue emergent police notice.
Lord, notice be issued, I can take instruction.
Let police
Because similar matters are pending.
Police go and threaten your officers.
My lord, similar matters are pending before this Honorable Court.
They are in appeal.
This is an appeal.
Appeal. This appeal is already order in passed.
I'll take instruction. I'll come back, my lord.
Request of learned AGA to accept notice is rejected. Issue police notice to the office. What is that? Officers, they want to harass the citizen?
No, my lord. My lord has given the details description so far the Gandhi Tagore is concerned. This can no way be. But I have gone through it, my lord.
We see, I am from another state. Okay. Last 1 year I have been here. I have been observing the abuse of contempt jurisdiction by some of us.
Yes.
It is an abuse of contempt jurisdiction.
Yes, first, second,
There is
third.
an order for compliance. If a complaint is filed, dropped with a direction to comply with the order. Unheard of any civilized jurisdiction.
My lord, with all said and done, we should confess to that extent, my lord, after kind interference of this Honorable Court, many of the things has been regularized in the meantime.
They should, your officers, I'm just waiting for a good matter where I can direct the imprisonment. Imprisonment we want to direct, but we are not getting that powerful matter. Therefore, we are deferring our implementation of our intent. And you show this video to your people.
I can humbly
That,
submit
they
that.
do not-
I will
they are
return
not-
back with the instruction.
In one good matter we are searching, where two civil servants, if they are imprisoned, things will come to the right way. We are unhappy. We are really unhappy. Your officers think too much of themselves. They should be taught a lesson to obey the orders of the court. Even orders of the apex court not complied with. See what apex court has said other day against your officers. I will not say more than that. We are just waiting for an appropriate case where, yes, policeman, returnable arm. Give it. Yeah? Application. 23 June. Right. Is it Friday?
This is division bench.
Charge 23. Yes. You tell your officers that courts are unhappy,
Yes, ma'am.
dissatisfied, angry. We show anguish. Tell them we have used all adjectives. Yes.
Item 10, writ appeal 9 of 2025.
Item 10, my lord, kindly recapitulate the yesterday's matter, wherein that so far particular the recall of the orders, my lord has not accepted the same, because some of the matters basing upon which this judgment was passed, that is pending before in the SLP, my lord, will not be appealed. On that ground, we have culprit, then that has not been accepted by my lords in yesterday. The same matters, my lord. Some of the residual matters are there, which is in the list.
In
But the same matter. When you are 6 months.
Yes.
For a moment. So for this one, my lord friend says that nothing to be said because he was being.
That's
Kali hitla pura.
Oh, that's it. Okay, famous.
yes, Madam Pami.
I'm really submitting, my lord. Yesterday.
He only himself said.
Sir.
He's very good in adjusting mood of the court.
Yes. All this.
Monty is a brilliant psychologist. all these applications moved by the state and their officials for recalling the
Not as a recalling, it is a repetition. Those cases same, identical to these cases. Their cases you also disposed of, dismiss the application, confirm the judgment of the single judge. These are the cases, that is writ appeal number
2851.
covered by which
2851.
My lord, that is one Chabindra Samal.
the writ appeal number
2851 of 24. Disposed of that.
2851 of
2024.
24.
Yes, disposed of on between
State of Odisha versus Chudamani and others.
versus Chudamani.
yes. But this is the order which they wanted to recall your worship. They rejected the application recall.
The matters, these appeals are covered by the
Yes.
state judge.
That's
All these cases were listed yesterday.
Yes.
recall petition, right?
They were recall applications.
Yes.
Now you are before the apex court also.
Yes, ma'am.
Not in this case, in another case.
My lord, no. Out of this,
But I am
these two matters,
producing the same matter has been confirmed by the Supreme Court.
Confirmed by the Supreme.
Yes. That judgment happened.
my lord, some of the matters is still pending. Yesterday, I have given the details of the copy, which has been in the month of February. Subsequently, it has been posted. I have given the details downloaded copy, my lord, yesterday.
When matters are disposed of by the SLP,
SLP, yes. Sir, I am giving that.
order of this court.
Yes. That is at phase.
My lord, so far the Chabindra Samal is concerned. Basically,
Page
which
18,
judgment has
page
been
18.
passed.
The judgment
That
of this.
SLP number I am giving, my lord. That is 34586 of 2025.
Page 18.
Which matter you are mentioning, Mr. Mohanty?
My lord, I am with the judgment dated 10 to 2026. Wherein the bunch of matters have been disposed of by this honorable court. May I supply the copy for the sake of convenience, my lord?
That Bholanath, which is that Bholanath, sir, not right?
Yes, sir. Bholanath also I have given at page.
No, that was Jharkhand it is.
Page 71.
That you have given for reference.
Which is a apex court judgment which affirmed the order of this court.
At page 25.
25.
Yes,
Of the memo citation.
Amit Kumar. Yes.
That is Amit Mishra.
Yes.
Mishra.
Page 25.
One is Amit Mishra, State of Odisha versus State of Amit Kumar
Yes.
Mishra.
Three judge bench it is.
Yes.
Another is State of Odisha versus Chabindra Samal.
That is at the
Taken
implementation
care
of
of.
page 28.
This was against WPC
Yes, sir.
order.
Yes, WPC order. WPC order is at page 18. Page 18.
This is identical matter.
Sir, identical. These are only mobile health units, sir. That same provision is. Implemented.
Page 18 is not correct.
Relevant is page 21.
Page 21 or
21.
21.
Relevant.
Relevant portion.
You're right. Yeah.
Though there are other judgments, we don't want to bother your worship with other by unconditionally. Yes, I can.
How many days of delay?
Worship condone the delay. Again,
Delay control reflection.
worship condone the delay.
In all these matters, how many days of different dates are?
But your worship, I think last occasion, worship condone the delay.
You have condoned that.
Delay was condoned. Order was passed, keeping in view the two judgments, my lord, of this honorable court. One is of State of Odisha versus Chabindra Samal. Second one is State of Odisha versus Amit Kumar Mishra. So far,
Now
the,
Amit Kumar Mishra has attained finally.
so far the Chabindra Samal is concerned, my lord. This matter was in the SLP. Number I am reading out, my lord. 34586 of 2025.
3, 4,
586.
34586.
Yes, ma'am. Of 2025. And it was in the board, my lord, 21st January 2026.
then what happened?
For my lord, it has been, the deal was condemned and then subsequently it was posted to, and delay was condemned and it is pending, my lord. That order and similar 6 matters that I have given the copy, my lord. This is kept pending under sub judice before the Hon'Ble Appeals Court.
Now we will say this is covered by our judgment in state of Orissa versus Chudamani. Correct?
Yes.
The subject matter of
Chudamani and all other matters in one stake, my lord.
correct.
May I submit the copy for the sake of convenience?
I think it is here copy.
It is there, my lord, for the.
Sir, Amit Kumar Mishra's case is three judges.
It is 3 judge bench.
Yes, page 25.
Amit Kumar Mishra decided
My lord, in 12th January 2021,
correct.
this was disposed of.
These are not implemented.
And you have implemented the order also.
That is at page
Subject to
At that point of time, the amendment rule was came into force.
Before that.
Subsequently, and that has not been taken care of by the Honorable Single Judge, my lord.
but that argument was made in Amit Kumar Mishra also.
No, my lord.
You have not made.
No. Amit Kumar Mishra is of 2021.
Amendment came when?
2020. So 27, 11,
Whether
20.
Amit Kumar Mishra mentions about
Yes, sir.
Yes,
Yes.
very
Yes.
Page 25.
Page 25 and 26.
26.
Page 25, we have heard non-counsel for the party. The plea of non-counsel for the petitioner is that in terms of Rule 6 of the Orissa Pharmacy Service Method of Recruitment of Condition of Service in 2015, the mode of selection prescribed by pharmacists through a selection process, and therefore pharmacists employed on a contractual basis under a different scheme cannot be regularized. On the other hand, non-counsel for the respondent has drawn our attention to Rule 4. This is amended Rule 4 of a very rule, which provide for such contractual pharmacists to be observed once they have completed 6 years of satisfactory contractual service through a deeming provision. In fact, the circumstances which who are yet to complete 6 years of contractual service are to be deemed to be contractual government employee and will be regularized as and when they complete 6 years of satisfactory service as per the provision. In view of the
Now, we passed one more order keeping this judgment in our view. Do you have that copy of the order?
so that
I vividly remember.
That is, my lord, Writ Appeal number 9 of 2025.
9 of 2025.
This is arising out of the WPC number 34165 of 2021.
PC number
34165 of 2021.
34165.
Yes, ma'am.
Do you have copy of that order?
that order from
I have got the noting, my lord.
We have disputed. Huh?
This is, my lord, party name is State of Odisha versus Sridhar Nag.
Sir, I have given another copy of the Honorable Supreme Court's order.
Wherein it has
We
been
have
Not
referred.
that. We have, because I
Enough.
vividly remember the last portion of order in Amit Mishra,
Yes.
Amit Kumar Mishra. This we have deliberated because Mr. Panda argued the matter, I remember, on this. We rejected that contention, saying that rule was amended, etc., was already traded before us,
Right.
to
unsuccessfully.
the effect from 2020.
Huh. Yes. Do you have that order in writ appeal number 9 of 2025?
Item 10.
Referred to this.
Order number 2 in patent number.
I have given the copy. Sir, Xerox ka dele ki? କପିଟା ଦେଲେ 3 ପେଜ ଦେଇଛନ୍ତି କପିଟା ଦେଲି କଣ କଲେ ନାଇଁ ଦେଲି ଏବେ 3 ପେଜ ହଁ ଦେଖି
The subject matter
ସେଇଥିରେ ପୁରା ଅଛି
of all these infra-court appeals by the state and its officials is substantially similar
କପିଟା
to
ଦିଅ
the one
ଏଇଟା ଦିଅ ତ
in WPC 1353, sorry,
ମାନେ
in,
this is the copy
in WPC 1353 of 2020.
This is the copy, my lord. I am support. That bunch of matters can have a glance to know.
Same model.
Same, my lord. And there the Hon'Ble Appeals Court order is there also, my lord.
We have stated that also.
Exactly. For the sake of convenience, I am so.
Same.
My lord, the honor Shabindra Samal order is there also. I have applied.
This order number 2 will cover everything.
Yes. ସେଇ ଯୋଉ ବଞ୍ଚ ମ୍ୟାଟରଟା ଯୋଉଟା ଦଉଛନ୍ତି ସେଇ ସିଙ୍ଗଲ କପିଟା ଥିଲା ଦେଲି ଏକ୍ସଟ୍ରା ମାନେ ଅଛି ସେଥିରେ କପି
Why are you sending a new workers?
ସେଇ ଜିନିଷଟା ପାଇଁ ରିପିଟ୍ କରିବ
They will not be knowing our pronunciation, our wording, etc. Okay, so only those who are working with us alone should be posted here. We cannot because she may not know my pronunciation.
We have to do courts. What's up? Either of them could be there.
Otherwise, everything we will see again and again. There. Have we made any observation as to implementation of the order?
I have given the copy, my lord. Hon'Ble Appeals Court also.
Direct
My lord's order and the next page, my lord. I have given the details.
Just
No, the direction.
It's a direction, my lord. Given.
there are some others left, same matter. Some.
Not listed today. Similar.
Post all those matters tomorrow.
One more matter.
Tomorrow, my lord.
Today only we will get them by special order today. Just to.
My lord, I have given that copy also. Shabindra Samal kindly.
Yes, we have kept that. Post those matters. Bring special list. How many matters are there?
15-20 matters.
Yes, get them. Get all of them. Get 2. Yeah. Tell lawyers to come. Whoever lawyers are there now, ask them to come.
All belongs to the same chamber, my lord.
Okay.
Almost all.
Post them. Vacation is coming and they will harvest it now.
There's one more matter left, but I'm giving the slip.
Give them.
Item 11, Rate Appeal 351 of 2024.
I am for the appeal. It arises out of a matter of a decree of divorce.
Yours.
My lord, for appreciation of the facts, a little bit of facts I am narrating.
What is that you have challenged here?
The quantum of maintenance, permanent alimony,
How much is ordered?
3 lakhs.
Permanent alimony 3 lakhs.
3 lakhs.
You are for?
I am to the wife.
3 lakhs.
You want to enhance it?
Enhance it. Honorable single judge refused it. Therefore, in appeal, I am before my lord.
Again, as to order of the single judge appeal is maintainable.
My lord. So far 227 is concerned, it is not maintainable. But so far, my lord, your lordship may look at one point I shall raise. A decree of divorce with alimony. Before the learned district judge, it was challenged. Since it was not a matter of family court, the honorable learned district judge is the appellate authority. Then he also refused that on the finding that no materials is available for consideration. No material need not be there. While court considering permanent alimony can apply its judicial mind for a lady because the decree of divorce is being granted. That having not been done, I approached the honorable single judge. Now he has rejected that.
On what ground he has rejected?
I could not place any material. I could not place any material, therefore, regarding income status.
No, there is one judgment of perfect court. No, whenever
Yes, that was not never considered by 3 of the courts.
Also take notice, let us see. My lord, issue emergent notice, return never within 2 weeks. Post immediate application. Okay.
Item 12.
3 lakhs given as permanent money.
My lord.
Whether that money is paid to you now, at least.
What was the husband doing?
No, we have not.
What was the husband doing?
My lord, he is unemployed. He is unemployed.
Any children are there?
No.
No children.
And how long was the
Marriage.
marriage?
Marriage continued for that I have to take charge. 2007, the marriage of Salaman.
What is the qualification of your client?
My
Is she employed?
no.
Not employed.
No.
What is that her qualification is?
That I don't know.
These are all essentials in any family jurisprudence. First requirement is when marriage took place.
Sir, I shall.
What are the
I am
qualifications?
sorry, my lord.
That is what court has said you didn't have any material. You must have.
You should have said this, that, etc. Here we stay. You take notice, let us issue emergent notice.
I am sorry, my lord.
All him who conducted there. You can't improve here. Yeah.
My honored friend must have been, so I cannot say it.
Sorry, I don't know. I don't hear my lord. The lawyers of the conducting councils, all names will be reflected.
So because different councils are there.
Okay.
Or actually difficult my part to make the harvestation.
Yes.
Item 12. Rate appeal 1708 of 2025.
This order reject request to the petitioner. Huh? Order
Backwards.
because in terms of Rule 91 of the Orissa Service Code. That is
91 of Orissa Service Rule. Service Code.
That says, my lord, if a person was dismissed from service on account of a charge of criminal offense and subsequently he was acquitted, then he is entitled for the bequeathers. Here, the petitioner was reinstated after he has been acquitted.
When he was
And now he is also retired.
He was removed, dismissed from
Service.
dismissed on.
Have not read this brief. By the time it has come. Sorry, my
Application.
sorry, my please.
Application.
Because this thing
Application.
is the only point to which. In the meantime, may I take I saw the copy on the
Issue. Emergent notice. That the DGA, Mr. Monsi, on request accepts notice for the other side. Matter lies in a narrow compass, which is in the second week of July. Next.
Item
Latest judgment has come on that Supreme Court
yes,
judgment.
that
has come.
our High Court also on judgment is there.
Not your High Court, our
Yes.
Supreme Court.
Yes, yes. The recent judgment of our justice.
Item 13. CMAPL 527 of 2023.
Mr.
The petition has been dismissed for default.
Dismissed.
Item 13 is due to
Dismissal for non-prosecution. Bad bill.
non-prosecution.
On merits, whatever we may do, if we dismiss this, how he should answer his claim? And why dismissal? So many matters are pending. Why can't we take those matters? Restore this.
My lord, here it's a matter relating to RSCP. Biharilal's case covered. This is. I am to cut for the service book so that we can access. I can access the stagnation in their service. Whether that is there any
We'll
stagnation?
recall that matter at least. We'll recall this matter. And you accept notice and post it.
Dismissal.
Oh,
The
wrong number. My
13. Dismissal for default.
13 dismissal order.
We should not dismiss for default.
sorry. I'm sorry.
No, in fact, we are against dismissal for non-prosecution, I tell you. Unless the lawyer is very recalcitrant, then we to secure his presence, we may do it. Otherwise not. So many other matters are there to take up.
Exactly.
Why to dismiss that? The matter was dismissed for default by order dated
22 March 2022.
2022 by a coordinate bench. First time. Now application is filed.
Yes,
Miscellaneous application or application? What is that called?
but application for the same APS.
An application in so and so supported by an affidavit is filed seeking recall of the orders and restoration of the case to the board. First time. Application is supported. The perusal of the application shows that there is a plausible explanation for the alleged default, and therefore the recall application needs to be favored, and matter merits to be restored to the board for disposal of merits. First time. In the above circumstances, application is allowed and case is restored to the board. First time is the case. It's a gratuity.
No, not recovery of rupees 1,30,000 from my pension.
Pensioner.
Pension.
Matter lies in a narrow compass and appears to be covered by the apex quotation in Rafiq Masi, 2015.
And recently also our own Sahu.
Other cases as well. First, therefore, post it in the second week of July. June, there will be vacation, no?
No, soon after vacation.
Soon after vacation. First week of July. Okay.
Another prayer, I filed my Bhakulatnama on 8/2/2022. My name do not find place in the list.
Registry to bring the name of Learned Counsel Sri Science Society.
Today also my name is not there.
Okay. Perhaps the registry is not happy with you. Take a small sweet box to them. That's what they will reflect your name. Yes.
Item 14, Read Appeal 195 of 2024.
What is it? Yes, sir.
My lord, this is that I was submitting, my lord. The matter related to RSP and covered by the case of Biharilal's case, Biharilal Barik's case.
Yes.
My lord, it is difficult to assess their service stagnations in this scale, my lord, unless you call for the service book of the respondents. So let's say, give me some time so that 14 and 15.
14, 15. Call immediately after vacation.
My
The
lord.
request of Learned EG. Yes.
Item 16, Read Appeal 218 of 2024. Item 16, Read Appeal 218 of 2024.
Yes, sir. State is a appealant, na?
Yes. My lord, this is a matter relating to
Comply with the order of the tribunal.
matter relating to pension. As your lordship decided yesterday, recruitment was held in the year 95. Advertisement issued. Result published in the year 2000, and the appointment made in the year 4/6/2007. So,
Now, did you challenge? What was the order of the learned single judge?
single judge order that
Implement the order of the tribunal. Did you challenge the order of the tribunal?
there, while allowing the prayer made in the writ petition, direct the extend the benefit of coverage under OCS pension rules 1992 and
This is which item? 7. You're 16 or 17?
16.
Yes, 16. Yes, 16. Beyond 15.
Mr. G is holding some, you are in advance.
no, I am holding a draft list.
Take serial number 16. Direction is for implementation of order of the tribunal. Had you challenged the order of tribunal? Court has issued
16.
this order.
My lord. Forest Department.
Order of the tribunal is directed to be complied within 3 months. Did you challenge that order? This order you cannot challenge as long as the order of the tribunal remains.
My lord, yes. Your lordship is right. Tribunal's order was also that way is allowed that modify the order dated at
Second
the
RSP.
second RSP.
Then that's order, you have to comply with the order of the tribunal.
Second
Orders of the authorities and tribunals are bound to be enforced by the High Court under 227.
Let me get
Like
instruction.
that, how still you implement the order?
My lord, let me get instructions.
No question of it. Take them.
No, whether they have
This
challenged it or not.
appeal by the, no, if you are challenged to file a review, then we will consider it. Perhaps they will not do all that. That officers are not that vigilant in your state. Sorry to say that.
But this is your appeal. You should have come with that. Made a appeal.
Saying that we
They
have
have
already
challenged the order.
been challenged this one, and this order is stayed, set aside, modified, nullified, rescinded.
No,
That is not your
Give
case.
me a chance, madam. See,
Call, call on Monday. Monday, the request now.
Item 17, read appeal 3421 of 2024.
My lord, I myself Jitendra Kumar sir, and appear in person, and this was the NOC from previous council.
Yeah. Yes, tell. What is the case about?
77. 659 more.
17.
Item 17, sir.
What is the number?
Your number may be different.
yeah,
Different.
yeah.
Please
yeah,
wait.
Parrot.
Wait, Asiva, 1880 will look in.
Yes.
With respect to extension of benefit under the OCS pension rule 1992 in favor of the petitioner man, in favor of the opposite party man, respondent man. Already Honorable Single Bench decided the matter and passed order with the direction to extend the benefit under the OCS pension rule 1992 and GP rule 1938 man. Because of the advertisement was issued in the year 1995 man.
You want to argue his appeal?
Yeah, read that.
Whose appeal it is? Why you are arguing?
No matter.
He will argue his case. If at all your turn comes, then you can argue. Yes. She was very happy that somebody is arguing my matter. I can take rest. Yes.
This is that matter what I had placed before your lordships yesterday, that the advertisement
We dismissed those appeals.
yes.
Similar order as well.
Similar order we have passed.
I started with this.
Yesterday also we passed this order. They remember. Sooner.
Where the advertisement was made in the year 95.
Yesterday.
I am correct.
You have changed everything.
Yes.
So you exercise your interpolate power. Delay of 804 days.
Yes.
Same order. Yes.
Item 18, read appeal 659 of 2025.
My lord, I got NOC from previous lawyer, and I conduct myself.
You conduct yourself.
My lord,
Conduct properly.
it is a 10 days delay, and I is giving.
We'll condone delay of 10 days, Mr. G. This appeal by the private party seeks to lay a challenge to Eleventh Civil Judges order dated 14/2/2025, whereby his WPC number 2278 of 2024 has been negatived. First off, a short delay of 8 days is proved in while 10 days is proved in filing the appeal, and therefore an application in IN number 1737 of 2025. 1737. Read it. 1738. 1738. 173 of 2025. You're right. Supported by affidavit is both seeking its condemnation. First, delay is short and explanations found plausible. First, application also, therefore, application is allowed and delay is controlled. Post this matter immediately after vacation. Okay. Which place you are coming from?
My lord, I am from Khurda.
How many kilometers?
90 kilometers.
90 kilometers. Then you take some date. You take some date. It becomes easy.
Before vacation.
Before vacation, you go to enjoy some other place. After vacation, you come, will be in the good frame of mind.
Short date after
Short date,
vacation.
you after vacation. You something.
24 June.
24 June. 24 June. All right.
I know partner. So can I?
Passover, which matter?
Item 8.
Serial number 8.
Serial number 8.
18.
8.
One eight.
Only 8 million. Only 8. 1 8.
Yes.
Item number 8.
It's a matter of transfer, my lord.
Huh?
It is a matter of transfer. The petitioner is working as the inspector in the income tax department, my lord.
Income tax
Tax department.
inspector.
Means, I know.
How many years of service he has put in?
In the recent place of posting, just before 11 months, he has been posted under Annexure 1.
How many years of service he has put in? Whether his service records are clean? Two answers.
Yes, yes, yes.
When he joined the service?
He joined service, my lord.
All out of syllabus questions.
Yes, yes. But my answer is, my lord, the present place of posting wherein the present petitioner is continuing, just before 11 months, my lord, he was posted. That is on 6/5/2025, my lord.
6/5/25.
My lord.
What is the retention period?
11 months, my lord, only.
No.
Sorry.
How long a person can
And
according
stay
to
in a one
transfer
particular post.
3 years.
3 years.
3 years.
Which rule it is?
And the rule I have annexed, my lord, under Annexure 4. 3, my lord. So when the other persons are there and continuing more than 4 years, 3 years, 4 years, my lord, they have been accommodated. But when I have been discharging my duties for last 11 months only to accommodate the OP number 6, the only malified I can establish, my lord, only to accommodate the OP number 6, my lord, I have been disturbed.
This is a violation of Shilpi Post versus State of Bihar.
My lord. And you lords may kindly peruse.
It's not that Shilpi Post. Party. It appears to be in violation of Shilpi Post versus State of Bihar.
It's a transfer.
Transfer to accommodate another person is a bad order. That's what Shilpi Post says.
But he is at the same place at Bhubaneswar, not he is going to some
No, why?
one department to another department.
Why he should be? To accommodate somebody.
It is not, administrative ground, I didn't have that instruction. But on the record, I've seen that he is in place from Bhubaneswar itself, from one place to another.
That's also transfer.
So transfer.
Transfer is from one office to another, not one place to another place.
So it is one seat to another seat.
Oh,
Huh?
from unit 2 to unit 1.
Yes.
No, even that is a transfer.
And the wording is a transfer,
There
my
is
lord.
a
The wording.
judgment of full bench judgment of Karnataka High Court, Chandra versus State of Karnataka. When he transfer is defined here, the policy is transfer defined here.
It is
From one table to another table is a transfer. That's what full bench of the Karnataka High Court has said.
the administrative ground.
That is all argued. Now you answer the question. What is meant by transfer? Whether for a transfer, change of place has to happen or change of table also can be.
Nothing you're
And the
transfer.
order says, my lord, it is transferred. The order itself says, my lord, it is transferred. The following transfer and postings in the grade of inspectors are hereby done, my lord. The wording says it's a transfer. And in the
So
first,
what is that call it? They may call it. What is transfer? Under the guidelines, what is meant by transfer? number one. What is the prejudice caused to you?
Ma'am, in normal courts, my lord, I don't have any objection if I will be transferred from this place to that place. But it's a humiliation, my lord, because the lords may kindly see under Annexure 4, the first transfer order was passed. And Annexure 4, lords may kindly peruse for a moment. My name was not there. Only the OP number 6 was there. OP number 6 was transferred to another place. And another Utkal Chandra, Utkal Padmaraj Hota was transferred to my place where I have been transferred. But only to accommodate their OP number 6, my lord, Utkal Padmaraj Hota has been returned back to that original post in which post he has completed 4 years, my lord. And in my post, this OP number 6 has been posted. This is my grievance, my lord.
Whether all they have taken charge? Charge is taken?
That instruction, my lord, senior can.
The order said that he took charge of second April 2026.
Huh?
The order told by the 20 or 22nd April 2026.
No.
Where there is a order is there, order is granted for Inspector of the Income Tax Orissa region, Odisha, order number such dated 13 March 2026. The following charges are hereby order for immediate
Changes are. Following changes are.
Here, my lord, we have given April,
No.
April 2 to say April 1.
Why? To favor somebody.
I don't know the internal issue, my lord, but threshold I can say.
The tribunal say.
The tribunal said the same thing because it is the transfer in normal course transfer in matter of transfers.
See what you are doing.
Yes, ma'am.
Whether that table is very profitable.
No. I have no hesitation to go, Miller. But only why they will accommodate some persons and the original person who is
Happening with you always, or this is
on the last in the last year, Miller, the same person, those who have made party, that was similar issue has happened.
Let's keep it to after 3 days. I'll ask the official to what is the internal arrangement. If it will be accommodated, then I'll place the clause. Right?
That's good. Unnecessarily suffering a bad order written with.
Yes, I'll talk to that CIT, and if the assistance.
Issue emergent the DST assisted by CGC number so and Mr. So and so on request accepts notice for the OP numbers 1 to 5. But notice has to go to OP 6. Emergent notice to OP number 6. First, it is open to the petitioner to take hand summons to OP number 6 to serve in addition to taking the usual steps.
Before the tribunal?
My lord, I was before the line of central line of
You take process for this.
Yes,
you take hand summons also to that person, Prahlad.
Yes, open on 6.
Post immediately after service report is filed in the register.
May I prefer some interim protection because
protection. You are already displaced.
No, I have not been displaced.
In the meanwhile, the party shall maintain status. If you are already displaced, it will be then. Okay. Yeah.
My lord, missing it there.
Are you done? After service. After service. Anyway, we have set status quo because if you have already implemented, we cannot change it immediately.
Maximum pass also. If not relieved, then status quo.
Yes, the
Status quo is there, no? Whatever.
It is better.
That's
This is decided case, my lord, decided on 4th. Covered case.
Another matter you not have decided where
They changed the.
No, I'm not changing my lord.
Why you want to
Then I'm just changing and
just check. In that, that's.
This is the case of the pre-deceased employee prior to 1482 of aided school pension case. She is not getting since April 2017. The court had directed.
How many days of delay?
Delay 266 days. In that case, now the delay was 187 days.
Huh?
In the case your lordship is handing, that is 187 days. Here it is 266 days. And after the second contempt filing only, they have filed this. First contempt was over, then second contempt. Thereafter also 1 month passed, and then they have filed this. Yeah, he died on 4/6/81.
5/6.
The subject matter of this appeal, both on merit and largely delay, is substantially similar to the one in writ appeal number 689 of
It
2024.
was decided on the question of limitation.
No, on merit.
No, merit.
Merit also.
Merits also, not said, have
Merits
not
also.
Decided on merit.
discussed about the
Nakara and other things. were-
yes, Nakara, your lordship have said.
Correct.
But here, the person died on 5/6/81.
Yes.
5/6/81, by then, the
4/6.
force, no, it's 5/6. died.
Upon New York synopsis.
All right, one day. How it makes
My
difference?
lord, the problem is that by then the 81 rule was not in force.
No, even otherwise you were paying the pension. You admitted it other day. While arguing this matter, when we asked you, you in so many words said that there was a provision for a family pension even before these rules.
Triple benefit scheme, provided they were contributed. Supposedly they are
2024 between state of Odisha and others versus Sisir Kumar Gandhi and others.
बसंत मंजरी बहता
At the next of the cognate decision, we have observed as well and dismissed the appeal of the state. First one. Next paragraph. Next paragraph is like this. Okay.
Because
Implement the order within particular.
because he was getting the pension till April 2017. Therefore, the area is also payable at the lower court had said within 3 months. And
Therefore, we said the learned single judge to be implemented within that particular.
the current pension was directed to be paid from the current month only.
No, whatever orders.
But that is there in the order now. That is there in
No,
the
you get that.
Then, my lord, therefore, I want to add something so that I may not be
No, yeah, like,
contempt.
it is their appeal. You are not in appeal.
My lord,
Next.
I may not have to file the contempt petition. That is how I have.
Yeah.
Item 22, WPC 16754 of 2003.
Yes, sir. Parliament in the group D post under the East Coast Railway, Khurdabad.
So this case, the petitioner filed a case, being argued, filed a case before the Lord and Central Law Tribunal and the central administration, first they have allowed the original application. A subsequent review has been filed without giving any opportunity review. Order has been reviewed. So that has been challenged before this court. And this court dismissing one line. So petitioner challenged the order of this court before the apex court and after remitted back to this court for a hearing on.
We passed the order in one line.
Yes, ma'am. And
This bench.
no, this not this meeting. Sorry, not this.
So matter is on remand here now.
Yes, madam. Unmarried. Your lordship.
Anyway, we don't doubt your version. We
Yes.
believe it.
Yes, madam. So
Though you are short to look at, you are a tall person.
if your lordship will permit me, I will prepare a date chart, madam. Your lordship.
When the CAT order is dated,
Yes, ma'am.
CAT order is dated
Yes,
what?
madam. CAT order. Page 45, madam. Page 45, madam. Read petition, page 40.
No, it is 260 of 10.
260, no, madam.
23rd July,
75 of 2006.
23rd July 2009.
23rd July 2000, yes, madam, absolutely.
Yes.
Your lordship have a glance the operating part, page 4. This paragraph is very lengthy, so I am saying that page 4.
23/7. 2009. Earlier it was allowed, OA was allowed in your
Yes,
favor.
my lord, I am reading out. Your lordship permit page 48.
48.
Yes, ma'am.
Go to 48.
Page 48. Second line, man, we are wondering how such a conclusion would be arrived at without leaving the opinion of the expert as contemplated in section 73 of the Evidence Act. It is not the case of the respondent that the verification committee, while arriving the aforesaid conclusion, has adopted any scientific method in the above circumstances. We are of the view that
Yes,
annexure A by 7
All right.
has also no validity at all.
All right.
Hence, we quash it as per the interim order passed by this tribunal. One post of gangman has been kept vacant. If so, that post can be filled up by offering appointment to the applicant within a reasonable time, at any rate within 30 days from the date of issue.
This order was recorded.
This, when the order not complied, my lord, the applicant filed a contempt petition. During contempt petition, my lord, pending of contempt petition.
Slowly. In the contempt petition number is
The contempt petition number I have mentioned in the
CP.
CP.
CP number.
CP number.
What's that CP number? All right.
CP number, man, 67 of 2009.
67 of 2009.
Yes, ma'am.
What happened to that?
Then the CP is pending, my lord. The opposite parties respondent file a review application.
Review petition number?
Review petition number, my lord.
Is it called review petition?
Yes, ma'am.
Review application. Review application number?
Review petition number.
RP or RA?
Array, review application. Page 58.
We asked for not page number. We asked for
Petition number. 17 by 2009, ma'am.
17 or 2009.
9.
Then what happened to CP? Contempt petition.
Contempt petition was pending, my lord, at that point of time.
At that point of time, he filed.
And after filing of the review application, my lord, the entire judgment has been changed, ma'am.
Changed after hearing you.
Without giving any opportunity, ma'am.
Without giving an opportunity.
Yes, no notice has been, no notice. I have specifically offered in the writ petition, no notice has been issued.
Then you
They
take.
have to judgment before the learning tribunal, my lord. That is covered matter. So your lordship may pass off. So accordingly, without issuing any notice, nothing but they have changed the order.
We'll issue notice now. If we pass order now, he will say to the Supreme Court that without hearing him, we have passed the order. Therefore, we have to issue notice to the DSG. Shall we issue notice to the DSG? There will not be.
Not because the review petition, my lord, they have passed according to the order of the Learning Tribunal.
You are for the What's your
Issue notice.
No, that's what we are.
Yes,
We wanted you.
yes, my lord.
Do
Yes.
that.
If your lordship, whatever your lordship feel.
What's your name, sister?
Sulochana Patra.
You are CGC. Nominate counsel for the petitioner tells that the review application 17 of 2009 has been allowed by the tribunal on 3 February 2010 and thereby reversing the order dated 23/7/2009 whereby his OA 675 of 2006 was allowed. First of all, he tells that there is a gross breach of principles of natural justice in as much as prejudice has been caused to the client. First of all, matter requires deeper consideration. Issue emergent notice. Learned CGC, right, sister's name, appears for, accepts notice for all OPs. All OPs. Matter, do you agree that we can remit the matter for consideration? Or you want to look into?
They have discriminated in, I have taken.
You want to look into?
No, Lord, sir.
Matter lies in a narrow compass called after vacation, summer vacation. All.
I am not the respondent.
You are respondent.
My lord, your lordship, the last occasion asked my lord the adjoint similar matter. Only this doesn't have find out.
Covered by judgment.
Covered by that principle decided by regulation. Yeah, regulation
Your is not here.
regulation has not been kept in abeyance after implementation.
That we have that matter we have allowed the petition, na? Appeal.
Again.
Where is your friend? Bring him.
Every lordship can see the order sheet. How many adjournments they are taken? They are suffering 2011. These persons. 1 to 2 is to retire by end of June, and another will return in January. Already one person already returned. So many occasions that by plea of adjournment, my lord, they are suffering.
Patient and subsequently take up in abeyance. Then they will see abeyance. That's the order.
You are arguing other matter, fast matter, batch matter, Mr. My lord.
Very same order.
My lord,
Principle is same.
principle is the same. Regularization kept in abeyance after the implementation. They are the board of directors in this matter, my lord, are directed to regularize. Regularization was issued on 10/8/2011.
10/8/2011.
All have joined in their respective place. After joining order of regulation implemented, on 19/8, the MD has so much passed an order kept in abeyance.
On 19/8,
19/8,
after 9 days.
after 9 days. Even though he is a party to the board meeting.
On what ground? You appear for OP.
Odisha Lift Irrigation Corporation
Appellant.
minutes. Yesterday night minutes, my learned senior has handed over me a judgment passed by your lordship. I need some time to go through.
We have not handed over Keshwananda Bharati case to you.
No.
This is only 4 pages. Read it now. Read it and pass over. There is nothing.
Minutes, may I pray? Let it some Monday.
No, nothing. Covered matters will not give time at all.
Minutes, this is not covered by that judgment, minutes. So I pray if your lordship will take it up on Monday.
No, nothing. Pass over. Pass over. Read and come back. We are not given some huge judgment to you to read pages. Yes.
Your Honor, I'm appellant. I'm from Bhubaneswar Virtual Court.
So my humble submission is that in respect to the order dated 24/2/2026, the university didn't allow. Yes.
Judicial officer's case.
No, it's the exam. Yes, sir. During the student at the time of 2010 to 12 student, at the end of the third semester class, he joined in the judicial service. Automatically didn't attend a single class of the fourth semester.
We had asked for order number 8.
So the university didn't allow anyone, granted exempted from the attendance in the past. According to the order 24/2026, the Academic Council said that never in the future, in the past, they didn't allow or they granted exempted from the attendance. But according to the rules and regulation, which are annexed in my counter, the university rules and regulation, in case of any student, in between the class, he joined for his sports on behalf of university, so that you take minimum attendance and that there is a chance they allow to appear for the examination or in the medical ground. But when the student didn't attend a single class and is not a student also, because on 9/1/2012, he joined in the government service. Automatically, the student is cancelled. And second thing, my humble submission is that after probation period, he didn't get a permission to attend a class because as per the rules and regulation, the university says that though you have to complete the course within the 5 years from 2010 to when he joined in the course, that is 2010 June, within 5 years. So after he joined in the 2012 in the government service, after complete of the probation period, he should get the permission, sir, to attend the class of a fourth semester. My humble submission, I mentioned the 5 grounds in the writ appeal. On what basis this examination is null and void, sir?
You have power to condone absence.
Sir, I did understand.
Professor, whether your university has power to exempt.
Yes, 4. Yes, sir. No, sir. There is a line 237 to clause 4. There is a 1, 2, 3 points are there. That's the 4th points. They have to exempt according to the rules and regulation. The rules and regulation is they have to attend the class, sir. There is a line is there in that paragraph. In the paragraph, the mention is like that. Now he shall, unless exempted by the special order that complete the paragraph. In the word, the exempted in respect to the rules and regulation, he should attend a class, sir.
Then where is the question of exemption? If he attends the class.
The exemption is to give the benefit even when he does not attend. That is the idea of exemption.
Yes, no, sir. When the attendance is shortest, in that case it is applicable.
No, wording, read the wording. Read the wording of the policy.
Sir, he shall also.
Days of attendance.
And sir?
It is not shortage of attendance. It is exemption from, suppose your Einstein comes to your class for learning theoretical physics. Will you insist on attendance?
No, sir. That is first thing you should be a student. No, sir. That is the one thing. One should be a student. These rules and regulations are applicable to the students, sir. One thing is totally is not a student. So he can allow within 5 years, sir. After the provision period, my humble submission, after the provision period, he can allow getting the permission from the higher authority, then he can.
For 4th semester, he has already attended.
No, third semester. 4th semester didn't attend the class, sir.
One second. He appeared for the examination.
And how learned single judge has reasoned out? Let us see. Go to order of the learned single judge.
Only they mention about the delay. They didn't go through the other points, sir.
In WPC 18381 of 2013, a direction was issued to you.
Sir.
And you did not comply, university did not comply with that direction.
No, university already informed him on what basis your application was rejected.
Now, where was the rejection order? He had given a representation on 17/7/2013.
So, so sorry, sir, I have no knowledge about the matter of 2013. I am going to matter of 2023. They assigned this case to 6972 of 2023. Yes.
You can't plead all that. You cannot feign ignorance of an order because that order, the very order is reflected in the impugned order.
Yes, sir.
No decision was taken on the representation dated 17/7/2013, despite a direction by the High Court. Then he filed another writ petition. And he filed another representation dated 27/10/2015 before the Vice Chancellor, requesting, I have got an order from the Honorable High Court to dispose of my earlier representation. And that you did not do. Then he filed yet another writ petition in 2016. And he is a brilliant student. Then since VC did not consider, then court directed academic council to consider the representation. How many times? Perhaps he has spent the entire youth instead of in honeymoon only in the court corridor. Then he filed a contempt case. See the conduct of the university. Your university thinks to be too high. Your university thinks to be too high.
No, sir.
Not care the orders of the court. Why we should interfere? No. University does not care the court. The court does not care the university. Simple. Tit for tat. That's how Hammurabi said, na? If somebody takes your one eye, take out both the eyes of that. That we cannot do. But see the conduct. You are in writ petition. You are in writ appeal now.
Yes.
And the appellate court is also writ court only. Intra-court appeal it is. Where is the conduct of the university? The conduct of the university falls short of expected conduct of the university. And you are teaching law. University teaches law or a disorder. Where, how many times this person should come to the court? Why we should interfere at the instance of a university of your kind, which does not have respect for the court orders? No, on that ground we are dismissing. Your appeal.
Yes, sir. I university. I on the
Appeal dismissed on merits. and also on the conduct of the university is not scrupulously obeying earlier orders given in a slew of cases. And they were not exploiting. First of all. Secondly, it is conceded before us that the university has power to exempt the candidate from attendance. First of all. Despite making representation, that power was not exercised, and therefore the power of the writ court is coextensive with the power of the authorities. Proceedings are called upon. Wider, which is that Kalingatives. Right from the Kalingatives of this mention. Yes, sir. Even otherwise, the order has brought about a just result to a most meritorious candidate. And first, dismissed. Any implementation is there?
My lords, the fourth semester we have appeared, the result shall not be published in the leave of the court. That was the order.
The
Order dated.
The order of the learned single judge shall be implemented within 3 weeks. Failing which the high functionaries of the universities run the risk of contempt action. Okay. Next.
Before I make my submission, this matter, 2 things which I would like to bring to your lordship's notice. The first is that this is a final hearing matter. If it is mentioned by one side, it should be with a notice to the other. Because we were taken by surprise when it came up in the list yesterday late evening.
When do you want?
But that is one part. Your lordship may just consider this. The second thing is, in course of the last hearing, when your lordship was hearing, your lordships had posed certain questions to me. Now, as to what are the methods of promotion, etc., is there a policy? Now, we have got all those things and we wanted to place them on record, which has been done through IA number 1714 of 26. That is not on board. In fact,
it immediately, in seconds it will come here.
No, the difficulty is we wanted to serve a copy on the...
We will give it.
He is not accepting it. He refused it.
My lord, at the last moment, on the last occasion.
Take that.
My lord,
So you don't want to look into those.
Yes, I'll look into it.
Otherwise, you will allow that.
No, I'll look into it.
You accept it. When
Yes,
the first thing is, when you don't have an advocate, you need not have. When you are appearing, it is with some concession we are allowing you. All people from Bakshi Bazar cannot come and argue. We will not permit that. There is institution of the bar. They know the procedures of the court, law, etc. Although you have right to address the court, is one thing. We cannot go on wasting time of the court with litigants when they say they will not accept the tender of the documents. What kind of conduct is yours? When lawyer gives, whether lawyer has no respect in this state.
Yes, my lord, I said.
First say sorry, accept it.
Yes, I'm accepting.
Say sorry first.
I'm sorry. But my lord, now let this matter come. Stick 12, 13 or 14, please.
You read that and come back. That is the right way.
And
Lawyer should have respect for the lawyer.
on the last occasion.
Lawyers, judges, they are part of the institution.
Yes, I understand, my lord. They are.
You understand so many things, sir. But we don't understand you.
Yes, sir, my lord, I'm with due apology.
Not to us, sir. You say it to Mr. Mukherjee and counsel on record.
But my lord, I am just.
Do you accept apology?
Yes, the endeavor was to...
Kindly give a date, man.
All right, we will give that, but conduct yourself properly. When lawyer gives something, we should take it with grace. You cannot agree with that.
I said, let the matter come, I'll take. That
you have not said. He's taking it first.
Call this matter immediately after vacation. Which place you have to come from?
Next week.
You can't dictate to the
No, I'm not dictating.
You may request and we will reject that request. which place you are coming from?
I am from Cuttack only, but
Cuttack only?
but
All this matter
just one submission, one prayer, my lord.
after vacation.
This matter was totally completely hard. Judgment was resolved by the Honorable Chief Justice.
Then we'll go before the Chief Justice and ask him, you decide the matter. Why are you sending it to other benches?
He has retired, my lord.
What to do? Then we bring the retired people here to work as a judge.
That is why I may not.
I'll be very happy if you do.
But I am praying is a short date.
After vacation, we'll have time.
On the first date of the second date.
Second day after?
Vacation, after vacation.
Second day after.
IA number 1714 of 26. We
Post all, yes. Along with the main matter. So and so. But let's have a question. The parts. Okay. See, those Mr. You should know one thing. Whenever you are appearing in a case and the other side is a lawyer, if he gives some application, you are bound to accept.
Yes, I am bound.
If you give an application, he is bound to, but you are speaking too much.
No.
That appears that way, going by your demeanor and
This is
other.
in my interest, my lord. Yes, I understand.
Don't talk much. Yes. Yeah, please.
This is a matter relating to area salary. Your Lordship would see the impugned judgment of the Honorable Single Judge. Our basic prayer before the Honorable Single Judge. My Lord was.
Senior sir, can I say one thing? You Lordship, kindly see the list. The list, the unserved notice returned from respondent number 5 and 6 with report addressee cannot be located health return. They are the card bank. The Honorable Single Judge are directed them to pay the amount. So they, unless they appear, they have, you've given.
He is the contesting bank. Our claim is against him.
No, maybe, but
if I can show, my lords, Division Bench, Supreme Court, same set of employees. They have said that Oscar Bank, my learned senior, will pay the amount. The single judge has somehow skipped those portions. The order runs contrary to a series of division bench orders and also the SLP dismissal order. Our basic prayer at page 21 before the Honorable Single Judge was to allow us to receive area salary in terms of the division bench order and in terms of the SLP order. That prayer itself is at page 21. That would be my lord's PDF page number.
May pray, my lord. Because of this noting, I have not prepared.
So this man is now 70.
Because of this noting, I have not prepared. I have to prepare a citation because there is a writ appeal judgment of this court that card bank will pay. That also I have cited before the learned single judge. Those bunch I have also filed before the learned single judge.
Yeah.
Also a writ appeal.
All right, sir. Which date you want to?
Your lordship may fix any date.
This man is on that 70 plus.
Maybe.
Area salary, Supreme Court it is
No,
covered.
yeah, and your lordship may say that this one of 5 and 40 is not required as he says. That is your lordship.
Meanwhile, you take no.
Yes,
Those banks, my lord, why my friend is saying, I'm not
allowing the judge to speak.
I'm so sorry.
What kind of?
No, I'm so sorry for my lord. Those banks are closed is what I was trying to say.
No, they are repented to somebody.
The banks are closed now.
They have been liquidated.
There is a
the liquidate official liquidator is there.
yes,
Liquidation process, liquidation process is over. The only bank from where I can receive my amount is from Oscar Bank. My learned senior is appearing. The Supreme Court also has confirmed such orders. I wanted to show those orders. And the
you implemented, you have arrayed other our OPs, respondents.
So, my lord, if I can say this, originally when we moved against Oscar Bank, my learned friend appeared and he said that that bank is under liquidation. Then we took steps to implead the liquidator of Oscar Bank as parties. Now we have impleaded, notice was sent, he has appeared.
No, I have appeared for the Oscar Bank.
Yes.
Not for the
Our
bank.
claim is against Oscar Bank only.
Lordship,
And
clarify because
the Supreme
your
Court-
Lordship, ultimately the direction, I have no quote. The direction is given to these two banks to pay.
Both the banks.
Yes, these two banks to notice to be given.
So is it true?
Yes.
So the
Your Lordship,
direction, my lord, is
Lordship,
against
your-
those two banks.
Yes.
Our relief is against Oscar Bank in the original rate.
But yes,
The learned single judge directed.
Against our claim is not against those banks.
Lordship,
Our claims is against him. And if your lordship would allow, I will just show 4 or 5 documents.
that has also.
4 or 5 documents only I will show. He's trying to.
We'll fix some day and
So may I pay for a short date? This man is 70 years.
Fix a date.
we'll have it immediately after.
Yes, what will fix the date?
Immediately after.
Yes.
Use 1 or 2 days after vacation. 23rd June.
We are great.
Both the sides are put to notice to argue the matter on merits.
Yes.
In as much as the essential prayer of the appellant is against the
Postcard Bank, respondent number 4.
respondent number 4.
Melons.
Who represent the other banks?
Other banks, Melons, they are closed. That's why they are not received.
Only closer, what happens?
Someone is in charge. To my knowledge, some government officer is in charge of that bank. That is exactly what I'm
No,
telling.
that's Melons, I will submit. I will only risk it.
Our concern, suppose if we pass an order without them, that will be stayed by the apex court and you will not get, your clients will not get the justice.
Melons, those banks are now non-entities. They have been liquidated. My friend knows that.
No, liquidated.
Melons.
After liquidation, what happens?
After liquidation, it's nobody is there in that bank. They are all closed
No,
virtually.
what is the role of the liquidator under law?
Liquidation process now is over.
Over.
All amounts disbursed till liquidation continues. We can have some grievance. After liquidation is over, nothing remains. That is, my lords, I'm sorry. That is why, my lords, we are anxious to get it from this bank because this bank is now also under liquidation.
Liquidated.
Now we have got documents that the liquidator is disbursing amounts to similarly situated persons. So as time progresses, the amounts may also dry up. We don't know the status. That's the reason, my lords, we are trying to get this matter heard early.
Then I don't, because
We have got documents to show that they are disbursing now. As on.
dispersing the money.
For others, they are disbursing.
What? They are giving some agreement, so 50% amount is given to them by a order of the state government. Now,
That's
liquidator
all.
is a state government servant.
That's all right.
Yes.
But where there are the first charge is always of the employee or employees.
No,
We are employees.
State bank. Exactly. They are employees.
No, but there's a document that we will be paid by.
Employees, blood and sweat.
Yes, I fully.
Go to the goods of the
Yes, I fully
produce.
I fully bow down.
Therefore, even under section 529A or something like that.
Of the Companies Act.
Yes.
Old Companies Act.
First preference is to make payment to the employees.
Exactly.
And if you make the funds crunch by making payment in terms of the state order, what should happen to this
No,
person?
that has not been done.
You are not.
No.
We'll record your submission that you are not.
Otherwise, may I request sometime next week because they are keeping on disbursing others.
No.
Next week we have some diff. No,
Your Lordship may say,
10 lakhs is the amount, roughly 10 lakhs.
Your Lordship may say, with the direction of the state government,
In the
who has
meanwhile-
made agreement with the
No,
bank, they are.
the OP number
Respondent number 4.
4.
4 is not there.
Not
7.
disperse
Yes, not this.
7.
any amount to
4
any
and 7.
Yes, ma'am. Yes.
till next date.
Yes, ma'am.
Otherwise, they may not get anything at
Yes,
all.
ma'am. Yes, ma'am. That I fully bow.
I'm sorry, my lord, 7. 7 is the liquidator.
OP number 7.
7.
Respondent number 7.
Respondent number 7.
Number 7.
And my lord, that 5 and 6 that kept up.
No, 5 and
because
6.
someone is repenting them. That is my instruction.
No,
As
then-
your Lordship says.
My friend only knows.
Numbers 5 and 6 is dispensed with.
My lord.
Means claim is essentially against
Right.
respondent number 7.
That
We are all great.
My lord, that matter that I have made a mention, my learned friend is there.
Which one? That contempt matter?
Yes, my lord.
Come.
That similar order has been given by this Hon'Ble Court. Out of 3 matters, in 2 matters, order has been passed. In third sub item, this.
What is the order we have passed?
Yes, ma'am.
Only just contempt should state the.
Contempt, don't precipitate contempt.
That is the only
lord,
order, my lord. That I have given.
This matter relates to the higher qualification.
Jenanani appears for whom?
In another matter, my lord, similar matter.
Same matter.
Matters.
Don't
This is not in the board.
contempt matters.
Yes.
So that
pressing. I am not pressing. I have already stated before the court.
well, the in the separate orders or both are same matters.
Yes, ma'am.
Yes.
All these matters together immediately after vacation. First come in the delay.
That's the
First come till the next date of hearing. the contempt proceedings in respect of the impugned orders herein are requested to be not precipitated.
Yes.
Okay.
Obliged, the blue.
Next. Yes. Yes, sir.
I had the privilege of going through the judgment just now. It squarely covers the issue.
That's what we said.
Yes.
Take down.
Though I had not read this, my lord, because it was handed over to us yesterday only, and my associate gave
Yes,
this.
read it briefly.
Yes.
It's a short judgment.
Yes.
What in that what you have done?
Kept in abeyance.
Kept in abeyance. Abeyance is kept in abeyance. Two things are there. Yes. The kindly be seated. Asad. Basanto. What? Basanto. 24.
My lord, excuse me, my lord, unlike my associate.
No problem. Keep your friend and
Yes, thank you.
Thank you so much for being fair to the court. The subject matter of this appeal. Yes.
Yes, Mr. Mahathir, you had shown us this, no? WPC?
Is substantially similar to the one in WPC number 329 of 2012, connected with the WPC number 1378 of 1994, between Bharat Behera and others versus state and others. Wherein we have granted the relief to litigants of the kind in the following way. Next paragraph. The order of the learned single judge is consistent with our judgment in Bharat Behera Supra. First of all, it is one of the cardinal principles of adjudication that similar matters should be treated similarly, there being no demonstrable differences having bearing on the matter. First off, in view of the above, the writ appeal to be dismissed. The writ appeal is dismissed, coupled with a direction to give effect to the order of the learned single judge within an outer limit of 8 weeks, without driving the respondents to invoke contempt jurisdiction. Okay, cost made easy. Yeah.
Okay.
Item 28, read appeal 2370
Yes.
Yes, short need check.
Give gist of the matter. Just make a statement in four lines, 5 lines.
The respondent, in working as ASI, Assistant Sub-Inspector Police in Railway Police Force, ad hoc promotion was given at the condition that he will not confirm any right of seniority, he will not claim for future promotion. 89 days promotion was granted to him. After 89 days,
89 days promotion.
ad hoc promotion. 89 days.
Then revert to the substantive post, then again promoted 1 day back.
After 1 day, again promoted to the sub-inspector police.
Sorry.
So this was continued up to his date of retirement. Since his date of retirement is fixed.
That means in every 89 days there is a break and he was continuing.
Yes.
It's artificial break.
For 2 years, for 2 years, near about 2 years.
No, why 89 days?
Because there is no sanction post.
For 89 days, there was a sanction.
For the post which he was promoted, that is not a sanction post. That is why since he has continued for a long period, 89 days promotion was given.
How many times you did it?
Up to near about 2 years. 26/9/2016.
Some cyclostyle orders, 89 days, 89 days, 89 days, that way. That is deprecated by the apex court in that ad hoc teachers, which is that Das case, 91 Supreme Court. 91 Supreme Court.
But there is a condition which he has accepted that he will not claim.
What? Where is the option? Otherwise, he will not get that also.
So, since his date of retirement is 34/2008, he has been reverted to his previous postman.
Why?
In order to regularize his service benefits, in order to regularize service book, etc., etc.
No, you give him the post to which you had promoted him. That's the order now.
No, that order is that reversion order. The Honorable Single Judge said that the reversion is hold good. There is no, even if he has been reverted to the previous post, so Honorable Single Judge allowed to the higher scale, which he was holding at the after the promotion, ad hoc promotion. That is under challenge in the state of
that he could not have done. Single judge should have said he should be continued in the promoted post, and then he is entitled to admissible pay scale. Having allowed him to go down and asking him to pay higher pay scale may not be correct.
Page 41 only, Your Lordship, kindly see.
But anyway, that is one thing. We will make it repair. We will repair that reasoning now.
And one more thing, my Lordship, kindly see the last 3 lines. That shall not be given effect, because failure of release of financial benefit from that may be.
Failure of release of financial benefit within 6 weeks of the communication of the judgment.
Correct. That's 6% no. 12% it should be.
No, that. Since you have prepared a writ appeal, that may be given effect from today only.
No, why you filed the writ appeal?
Because Your Lordship, kindly see, a number of employees has been promoted.
What to do? Why did you promote them?
Because there is no sanction for we have promoted. Why did promotion and he has accepted?
Why did you promote him? If there are no posts, why did you? No, 6% we don't agree.
And
you see that Chandrasekhar Kambara versus Bangalore University, 12% it is.
And one more thing, my lord, as per the pension rule of Railway Service Pension Rules, my lord, as per Rule 20, it said that unless and until that I have annexed, my lord, for his claim to the higher post, he has to regularize in a particular period for a particular scale of payment.
Now we are asking you, if there was no post, why did you promote him? Promotion, Justice Ramajais says in his famous book, promotion means from one lower grade or post to the other higher grade or post.
And higher responsibility.
And higher responsibilities.
But that is a provisional promotion.
Why did you do that? Provisional, how long it will continue? Every 90 days, 89 days, you are going on like that.
Did he volunteer for that?
Till the sanction post is
till that period.
Till the sanction post, till his post has been sanctioned by the, till his post has been sanctioned. So, but
when the post was sanctioned?
Till his retirement, that post has not been sanctioned.
When it was sanctioned?
That instruction I don't know.
We'll modify the reasoning of the learned single judge. So, Mr. Paddy, having done this, what is this? You should.
That's why
you always bring a strong candidate to argue here.
9/9/2025, the coordinate bench passed an order enlightening the same partnership for a movement HMSC.
Which is that?
9/9/2025.
9/9/25.
Yes.
In this case,
they have observed the same. But here in this case, what happened?
Indrapajal Jadhav and the Union of India squarely covered in my case, my lord. I am not claiming promotion. I have only promotion benefit. But only in pen and paper, they are revert and promoted. But I am doing this work.
Unless you hold the post,
yes,
you can claim salary and pension. Last pay.
I may hold the post since more than 2 years above.
Correct.
Only in pen and paper, they say revert 1 day back, then promoted in the SIP promotional post.
The rules provide, say, suppose there is no sanction post, without affecting the financial benefit, the authority concerned can give a person to a particular post for some period of, but for a temporary period. That's why they are observing the 89 days to a particular post and therefore reverted because there is no sanction post. The authority concerned, the child is confined to that post. Only for the sake of recognition and for their service, rendering service to the particular senior post, we are recognizing them. This is the rules for 20.
Which rule? This reminds us that case of Madras government, where they went on issuing ordinances every 6 months. Because the lifespan of an ordinance is 6 months. It will lapse, then they will issue one more ordinance.
Like
They will go on.
last 144 CRPC order.
CRPC order.
60 days. 60 days.
That you cannot do. That Kapoor versus Union of India. Take out that reasoning you will find here. Kapoor versus Union of India or State of Tamil Nadu.
Reflected in our counterpart way provide that rule. Rule 20 of Railway Service Pension Rules 1993. That rule 20, just like in this one. Chapter 3, qualifying service. The commencement of the qualifying service. Subject to the provisions of these rules, the qualifying service of the railway servant shall commence from the date of taking charges of the post to which he is first appointed, either substantively or in the officiating or temporary capacity, provided that officiating or temporary service is followed without interruption by substantive appointment in the same or other service of the post.
Correct. To overcome this rule, what you have done is 89 days, 89 days. That is not permissible. Because rule says uninterruptedly, without interruption. That you wanted to put in bracket. He is interrupted. Therefore, he is not entitled that way. No, that will be very unjust on your part. The employee has worked. How many years of service you have put?
More than 38 years ago.
38 years?
Yes, my lord.
2 years.
My lord,
No, it was 2 years. But total service is
38 years. But my lord, it was 6 pay commission clearly.
The null practice in the case of join as a constable. He is property to Havildar, then ASI. But
Promotion,
authority can, even though there is no sanction code, suppose he is a good worker, he is doing well. So for recognition of that, they are giving a temporary status for some days.
Is it your case?
There is a, I don't
No.
It is not your case that to favor him,
he has given a
give
provision
this
of 89
favor.
days only.
Huh?
89 days, then given, because there is no sanction code, no financial effect only there. So 89 days, again 18 days, they are content.
You have given him ad hoc promotion. You have never asked for a officiating. Had it been a question of officiating,
He will get only
allowance only.
not the salary.
That you did not do.
It was 6 pay recommendation, my lord, pay commission. The cases of person holding a higher post purely on ad hoc basis shall also be considered by the screening committee along with others. They may be allowed to benefit of financial upgradation or reversion to the lower post if it is benefit vice versa to pay drawn ad hoc basis, my lord. In 6 pay commission, my lord.
Then this is absolutely correct. You that.
I provided.
You have given that.
Yes, ma'am. In railway, my lord. In railway.
Railway.
Yes, my lord.
Minister.
26.
And this will increase that rate of interest.
That may be intact.
6%. Dismissed. What 6%, 3%, 2%? It is
8 months.
all right. It is his, you are not filed appeal. You cannot take bath under the umbrella of theirs. It's a leaking umbrella. That's another thing.
He is receiving the entire benefit. He has already received the entire benefit.
Agree. Okay. So now you are also taking because of this. Last. We'll come back. We have many orders to sign. Yeah.
Hey, what's the
Any updates?
Joint matters are there.
We are at 29 now. Please wait. Maybe wait.
Goes back.
Yes, 29. Going for 29, my lord have directed me. Sorry, I have taken time to produce some judgment. I have collected one only. I have got two other. Can it be added to some other dates or with some other? Because the only point they raised that the point he involved in this case, my lord, the 17/9/2007, they're getting the date. On the date, Finance Department issued the notification with regard to amendment of the new pension rule. The selection made prior to 1/1/2005.
Anand Das
Appointment
is there, my lord.
You want a shorter accommodation?
I just get there.
What I humbly submit, my lord, it appears that the writ petitioners have represented before the government. That representations were forwarded by the district judge before the government. Government has not considered, has not taken any decision. In the midst, they have come before your lordship. So the government will be granted 6 weeks time to consider and take a decision, because a series of representations, series of facts are there. All the, because the appointment order is different. My lord.
Date of appointments are
Date
different.
of my appointments are different.
That can be done.
That can be done.
Petition prayer reads as that. First one. After service of notice, learned AGA appearing for the OPs draws our attention to a slew of representations which official OPs have to take a call on, in accordance with law. First one. He submits that if a reasonable period is accorded, a decision would be taken on all these pending applications, representations, after giving an opportunity of hearing to the representers if need be.
Good.
First up. Learned counsel appearing for the petitioner caveats that not only decision should be taken, but be communicated to his clients so that in the event an adverse outcome is would be there, they would be able to take recourse to law again. First up, we agree. Next paragraph. With the above observations, this WP is disposed of, giving a period of six weeks for the government to take the decisions on the subject representation and also to communicate the decision taken.
Speaking order, by speaking order, what's the specific?
It makes no sense because to the concerned employees. First up, all contentions of the parties are kept open.
Grateful.
First up, it is open to the petitioners and the decision maker to solicit necessary information or document. It is open to the decision maker to solicit any information or document from the side of employees.
Or the concerned authority, that is the district judge.
From the concerned authorities, as the case may be, for taking a meritorious decision on the subject representations. First up, however, in that guise, delay shall not be.
Grateful.
Ordered accordingly, writ petition is disposed of. No problem.
Item 30, inherently this counter is not served. Now I'm giving a copy on the petitioner counsel as well as opposite party number 6. I am appealing for opinion 1 to 5.
You just go through.
No, sir. Go to 5 the agenda.
That's one, if you need.
Will come up to
You find counter in the registry. You have served copy on them now.
Sir, it has been filed.
Already.
Oh, it is already filed. Copies are.
Okay.
Copy is inadvertently.
All right. At the request of bar, call this matter immediately after vacation.
May I brave Lord?
Interim order may be continued.
Interim order to continue till then.
I am appearing for the opposite party, one of the opposite parties, and this is a matter relating to promotion, Your Lordship. Can it be in next week, any day?
Next week, we have, now only urgent matters we will take because there will be very urgent matters. Otherwise, we will be doing injustice to many litigants. Yes.
The petitioner is enjoying the interim order since 1.5 years.
1.5 years. About 1 month he will be enjoying more. Yes.
Reopening week, Your Lordship.
It will come after immediately. Okay.
Item 31. Needs to 119 of 2024.
May I please, my lords? Well, this is a case of regularization. My service terminated during pandemic COVID-19, that is on 31st May.
What is that apex court judgment?
My lord, I have relied upon Jago and accordingly a court bench of this court passed an order on 22nd 1/2025 in my writ petition, my lord. First order of this. Thereafter, subsequent decisions, Dharampal and others, my lord. But relying upon the judgment of Jago, an order passed by a court bench on 22nd January 2025, my lord.
22nd January.
My lord.
January?
22nd January 2025. In my case, in this writ petition.
It's a case relating to regularization.
My lord.
What order you have challenged here?
My lord, I challenge the order under annexure 12, my lord. Passed by the tribunal dismissing my original application number 324 of 2021, my lord.
Tribunal.
Tribunal.
That tribunal was working at the CIT administrative central CIT.
CIT, my lord.
What it says?
Tribunal relied upon the judgment of
Uma Devi.
Umadevi.
My lord, I am appearing for opinion number 2 and 4.
2 and 4.
The Indian Red Cross Society, my lord, Odisha branch. And my lord, I have prepared a counter to be filed. I am filing it in the registry and serving copy to my learned brother. So,
But this is 2024 matter.
my lord,
Your rules say counter to be filed within 2 weeks.
my lord,
2 years are over now.
the matter was listed. I have
Why
entered.
it should be listed? For
My lord,
filing of
no,
counter.
my lord, I have entered appearance during February. I am sorry, in fact, would have been filed at the earliest.
On the vacation at the request of the Net Council appearing for the office. It's covered by judgment.
Well,
Yes.
may I play, my lord?
After vacation. Yes.
Item 32, 3.267/2025.
32, my lord, I am for respondent number 3.
You have threatened counsel for the petitioner not to come here. State is the, you are for OP?
3. Respondent number 3, my lord.
Okay. Lalatendu Sumantrai.
Our president.
Our president, Bar President. Our president has gone to the Bar Association.
Probably he will be the senior advocate.
We will file our reply.
You will file your reply.
In fact, my lord, no reply is necessary. We will also be considered in any other date.
Abilities.
Yes.
Where is the question of reply? Any new development has happened?
He is before
the first
before any.
After vacation? After vacation. That's the request. Yes.
My lord, 35 is also same. 29 and 35.
29 and 35
Yes.
altogether. 29.
I'm sorry, my lord. 32 and 35. I'm so sorry. I'm so sorry. I'm so
29 we
sorry.
have disposed of.
Yes. I'm so sorry. 32 and 35.
Yeah.
Item 33, 3.77/2025.
Yes.
The state is the appellant, my lord. And my lord, we have assailed the order of the honorable single judge only on the premises that one vital finance department resolution dated 4/9/2012, that is at para 6 and running page 27, the honorable single judge has taken cognizance of that resolution, which is contrary to the claim of the petitioners. But in fact, in the concluding, my lord, the observations, he has bypassed that finance department circular, which is governing the field, my lord, so far as the regularization scheme is concerned, because the state government has formulated a scheme, finance department itself, and that scheme was neither challenged before the single judge nor, my lord, the single judge has interfered.
How many years of service the respondent has put in? How many years?
29 years.
29 years. Whether a scheme will prevail or a best court judgment will prevail.
That is the scheme.
Nothing. How many
It
years?
has got financial implication, my lord.
Every regulation will have financial implication. Every appointment.
Therefore, we have formulated a scheme. Uma Devi mandated to formulate a scheme.
Therefore, Uma Devi is diluted. Uma Devi is diluted. The MLK, Sari, Chago, so many other matters. Shripad.
New dawn has come.
New regime, kind of.
How to do? And that too, appointment
Notional
was,
regularization it is.
yes,
It's a notional where is the question of other thing?
financial benefit.
Even that argument falls to the ground. State and its officials are in this intra-court appeal. First, they seek to lay a challenge to the learned single judge's order dated 23/7/2024, whereby respondent employees WPC number 37540 of 2023 having been favored, relief has been accorded to him as an question. Next paragraph. Kindly be seated.
No, my lord, the observation is that to extend pecuniary benefits.
Pecuniary?
Yes, that is the observation.
Still. No, that ground goes does not mean economic benefits cannot be granted to the.
Notional regularization and the pecuniary benefits, my lord.
It's a wrong submission, your lordship will see.
Your lordship may see page
76.
77.
Your submission that it is only notional.
Honorable single judge have said that.
Notional.
Notional revenue.
Then we will record your submission.
And that too for a particular period. 82
Yes.
still. The rest of the period is there.
Already regularized.
Already
92 to
2016.
2016.
That is the only period you are asking.
Next, after service of notice, the respondent employee having entered appearance to his counsel resists the appeal, making submission in justification of the impugned order and the reasons on which it has been constructed. First off, learned counsel appearing for the employee vehemently submits that the regularization period is for the regulation is for the period between 1992 and 2016, and that it is sans any financial benefits, the same being made clear as notional. First one. Next one. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter for the following reasons. How much money with the delay in this?
Delay probably earlier control.
Earlier control. Delay has been controlled. 29 enable 25 order.
The records reveal that the respondent employee has put in a long service of about a little less than 3 decades with no complaints whatsoever. First up, the vehement submission of the AGA that every regularization, the regularization of the kind would have implication on the state exchequer, and therefore that would not have been accorded in ignorance of the scheme of 2012. First up, this is a bit difficult to contain in as much as scheme of the kind is in the light of decision of the apex court in Uma Devi, state of Karnataka versus Uma Devi. First up, the ratio in Uma Devi is not a final word. First up, law has marched from Uma Devi to ML Kesari to Jago to Shripad to so and so.
Bholanath.
First up, learned next paragraph. That being the position, the ground urged in support of the appeal does not impress us. Next paragraph. Above apart, as already mentioned above, the regularization period spans between 1992 and 2016. First up, the impugned order itself shows that the said regularization is sans financial benefits, but is only notional. First up, therefore, the argument that the regularization will drill a hole in the state exchequer has to fall to the ground. First up, a perusal of the impugned order reveals that the learned single judge has considered all aspects of the matter consistent with the regularization jurisprudence as evolved by the highest court of the country, case by case, and therefore, no, there is absolutely no justification for us to upset the scene. First, in the above circumstances, this appeal being unworthy of merits is liable to be dismissed, and accordingly it is, courts having been reluctantly made easy. First off, the appellants are directed to give effect to the impugned order of the learned single judge within an outer limit of 8 weeks, and file a compliance report with the Registrar General of this court, failing which they run the risk of contempt proceedings. Next. 16 matters. Listed today. They are disposed of along with main matter. So 14 are listed today. Same order.
Same order.
Which? Same. Delay, etc. Just yes. You instruct him. Yes.
The Lordsmith may kindly turn to page 20 of the order of Hon'Ble Single Judge.
Page 20.
Madam.
Why were you before the learned single judge?
Enter case is that he approached the Hon'Ble Single Judge that his voluntary retirement was accepted with effect from 30th June 2006.
Was accepted.
Yes, madam. WRSP rules come into force with effect from WRSP rules 2008 with effect from 1/1/2006.
Prospective.
Retrospective.
Retrospective.
WRSP rules 2008. It has been given effect retrospectively with effect from 1/1/2006.
1/1/2006.
As he retired, his voluntary retirement was accepted.
2008 amendment.
No, that rule is 2008.
Main rules.
Main rule is 2008, given effect with effect from 1/1/2006.
And his was accepted on 30th of June.
Already accepted.
My lord.
But with this is with retrospective effect from
1/1/2006. WRSP rule. He was not extended the WRSP rules 2008. Accordingly, he approached as I retired on 30th June 2006. That is applicable to my case. If that will be accepted, my lord, his pay will be revived under WRSP rules 2008 and his pension will be revived.
My lord, Lord friend is submitting on the merit of the case, but he has assailed the order of the Hon'Ble Single Judge.
That I have shown on last August, my Lord friend was not there.
Oh, I was not there. I do not know what happened, my lord.
Yes, my lord. I have shown that. My Lord friends.
I was not there.
Yes, I was not there.
What has happened, my Lord?
Oh, Lord.
In fact, that was dismissed on the ground of withdrawal. In fact, that was the counsel who has filed that application for withdrawal. He died and subsequent counsel filed an application. Wrongly, it has been withdrawn. Accordingly,
Lordship may remand the matter before the single judge.
Because it has retired, my lord, the very small point.
Single judge has not opined anything on the merit, bro.
Not written.
No, not opined anything.
Then how can where is the appeal?
It's a withdrawal.
Consent of the parties will remand it.
Yes.
So that we will have the appeal means.
Yes,
there should be a view on the merits of the matter.
Yes, I understand, my lord.
Court below.
I understand, my lord.
This was recalled. Order is recalled now.
No, my lord. That again, I filed an application to
pass
recall
that Annexure 2 and Annexure 3.
That was rejected.
Annexure 2, Annexure 3, your lordship may quash and remand it.
That's one. Why recall order application is rejected?
Because once withdrawn, you cannot comment.
What is this?
No. That has transpired. That's why I'm saying that the facts. But your lordship is doing.
And my lord friend is right. That transfers from that order.
Yes.
This intra-court appeal seeks to call in question the order dated
My order 15, two orders I have challenged.
27/8/2024
7/8/2024
And 15/7.
whereby
and 15/7/2025.
petition, the appellant's WPC OA number 151 of 2017 was dismissed as
Withdrawn.
withdrawn. First. Subsequently, an application was moved seeking recall of the said order so that the petition was restored to the board and heard on merits. First off. That application came to be rejected by the order dated 15/7/2025 by a learned single judge of this court. First, that order is also put in challenge before us. Next paragraph. Both the sides standing tall at the bar very fairly submit, and we agree that the orders in question should be invalidated so that application for recall is favored and main matter itself is heard by the learned single judge on merits, keeping open all contentions of the parties. First one, ordered accordingly, and writ appeal is allowed. First one, impugned orders are set at naught. First one, appellant's application in IA number 39 of 2024 has been favored, and as a consequence, the order dismissing the writ petition stands recalled. First one, writ petition to be heard by the roster bench in accordance with law, with the participation of stakeholders.
Great.
All contentions.
Public.
Yeah. You give some book to association library.
That man has read. If your lordship directs, I can give, but I cannot compel that man. I will give your lordship direct.
You need not.
Your lordship direct. I'll give.
We can't direct you. We could have directed the litigant, but you are saying he's not in a position.
In fact, he's not in a position.
No.
But on his behalf, I can.
You are for accountant. Show them off. Penal counsel. Yes.
Yeah.
Please, Lordship.
Yeah.
My Lord, 19527, we are for the OP number 3. We are seeking for some time to file a counter.
Counter you have not filed.
No, my Lord. My Lord, in the next one, 20370, we are for the petitioner. My Lord, we have not received counter yet.
Lord, I am appealing for the petitioner in the past case. And, yes,
You
Lord.
give papers to him and he will give his papers to you.
Yes, Lordship. So I did 1 week time. Only 1 week because it is already prepared. Since the union register, the secretary has changed in the meantime. So I need only 1 week's time. I will file the counter in the next.
My Lord, kindly be taken up after vacation.
After vacation, we'll call this. In while we will explain the pleadings.
Lord, the union is deprived of the benefits, statutory benefits under the Industrial Disputes Act. So I pray that if it is sorted before vacation, pleadings will be completed.
Appearing in these matters to exchange their pleadings, so that pleadings would be complete and matter can be taken up for a hearing on the next date of hearing. Next date of posting. First, call after vacation, as requested. Next.
In this case, the petitioner is challenging the order passed by the Central Administrative Tribunal under Annex 1. The brief fact of the case is that the petitioner earlier, on the basis of the ordinance issued by the Staff Selection Commission for Assistant Archaeological Chemist with requisite qualification at page 66.
Page 66.
66.
Why were you before the tribunal?
Before the allow me to participate in the examination for Deputy Superintendent Archaeological Chemist, the advertisement on the advertisement issued by the UPSC. But they are not allowed, rejected my application, for which I approached the Central Administrative Tribunal.
And they rejected why?
I am coming, my lord, on the ground that the lack of essential educational qualification.
That's fine. That's the case.
That is the case only.
Show us that you have
That I am showing, my lord. Earlier, the petitioner has
necessary. Where is the qualification? Come to the point. All these are 5 minutes.
Essential, what are the essential
qualifications?
Sir, my lord, page 41, Annex A/2, the advertisement issued by the UPSC.
41.
Go to
41.
Essential education qualification. Bachelor degree in my lord, my lord. Bachelor degree in chemistry or master degree in chemistry. Essential qualification and experience.
Essential qualification is chemistry.
Bachelor degree in chemistry.
Graduation or PG.
Or master degree in chemistry. And subsequently that, my lord, experience. There is 3 years experience in the use of the analytical instruments or method of analysis of organic inorganic materials from the recognized University Institute of University. For master degree, there is 1 year experience. For bachelor degree, there are 3 years experience, and for master degree, only 1 year experience is required. The petitioner is eligible in both the conditions. In bachelor degree,
3 years experience and he has 1 year experience also.
1 year experience also. Because petitioner has joined, that I am showing from the very beginning that page 67, he has joined as Assistant Archaeological Chemist on 3 July 2019. 3rd July 2019.
Where?
My lord?
Where?
This under opposite part number 4.
Number 4.
Archaeological survey.
ASI.
Yes, archaeological survey.
He went to ASI when?
On 3rd July 2019. Page 67.
3/7/1990.
2019, sir. 2019.
2019.
Sir. Sir, page 67.
1 second. Where are you heading?
No, sir.
You want your case to be dismissed? 3/7/2019.
19.
You did your BSc when?
My lord, BSc, my lord, my certificate is at.
We don't talk that. We have asked a question, answer that question. Don't tell cock and bull stories. When did you complete your BSc?
2008.
Give the date.
Marksheet is of 7/6/2008. You have a marksheet.
Sir.
7/6/2008.
7/6/2008.
7/6/2008.
Sir.
How degrees when a person is said to have graduated in your state? Supreme Court said graduation takes place when ordinarily the convocation takes place and degree is awarded. In your state, what is the legal position?
Yes, that's it. It's inserted from Osmania.
Osmania University.
Andhra Pradesh.
Andhra Pradesh. And also completed MSc in chemistry also.
Don't jump like that.
Sir.
First, when you got that degree certificate, where is the degree certificate? A degree is completed on the issuance of degree certificate. A degree certificate may be issued ordinarily after convocation. Sometimes, if the rules provide, can be issued pre-convocation. That's the law. Where did you have the degree?
That certificate I have not enclosed because I am taking into consideration the MSc chemistry.
MSc. Yeah. So
MSc
this
certificate.
degree we will leave now.
My lord.
Come to MSc. When did you do MSc?
That is at page 37, May
We do not know all that.
2011.
May 2011. You joined ASI on 3/7/2019.
19.
And you worked for how long?
Till date, I am working as a standard physical chemist.
So that itself constitutes experience is your contention.
Contents, my lord.
What is
Subsequently,
one more thing?
more things, sir.
Yes.
What happened, sir? On the basis of this advertisement on page 41 by the UPSC, the petitioner has submitted his online recruitment application, ORA applications, taking into consideration his master degree in chemistry
And bachelor's degree in chemistry.
No, not master degree, because there is only or.
Only master's
Since there is
degree
only
experience.
There is only or, so master degree in chemistry, but the petitioner has completed master degree in chemistry as from analytical chemistry, because there is a subject as analytical chemistry, master degree chemistry, and subject is analytical chemistry.
They say that is not proper.
So, my lord, when they rejected first, my lord, at page 49, without any reason, they stated that lack of essential qualification, they rejected by roll number. In that letter, it is indicated that candidates who desire to represent against his or rejection in accordance with criteria at page 53. At page 53.
You can make a representation.
I made a representation that because I have both experience, bachelor degree in chemistry, because a person without bachelor degree in chemistry cannot do master degree in chemistry. So I have bachelor degree in chemistry with 3 years experience and master degree in chemistry with 1 year experience.
Where is prescription of qualification? Let us read that.
Page 41.
4.1.
4.1.
Go to 4.1.
Of my relative please. Essential qualification. Bachelor degree in chemistry or master degree in chemistry.
41.
41 is some other.
We are not on the page 47, it is like.
47.
Yes. The UPSC advertising.
Go to 47.
Page 47.
Essential qualification, educational, 2 years. Bachelor's degree in chemistry or master's degree in chemistry. Experience for bachelor's degree in chemistry, 3 years experience in the use of analytical instruments or methods of analysis of organic or inorganic materials from a recognized scientific institute of university. Well, your OP3 is a recognized institute of chemistry.
No, they are projecting analytical chemistry. What they have rejected down, it is not equal to chemistry. Advertising for chemistry only. Either bachelor degree in chemistry or master in chemistry. Experience part, they are relaxing 1 year, 2 years. But he has not possessed the certificate in respect to the chemistry concern.
But chemistry is a genus. Other branches are species. Where have you said? He should be, how can you say that analytical chemistry does not fit into chemistry? How can that be? What is the reasoning? Whether it is correct or not, the apex court said, you should refer it to UGC. You can't decide whether it is true or wrong. How can you decide? What is your qualification? Apex court said in one matter, I remember in a question arose, whether X degree is equivalent to prescribed degree or not. Then apex court said, we cannot decide. We will refer it to UGC. UGC will decide.
Education part is qualification.
You cannot decide because you don't have expertise. Either you have that degree nor that other degree.
Sir, it has already been settled by the UPSC in earlier, this same post for earlier advisor in 2017 at page 70, kindly perused.
And UGC said what?
UPSC issue advertisement for the same post in 2017.
And they accepted analytical chemistry.
My lord, kindly peruse 70, page 70.
We want.
Yes, my lord. They've stated, my lord, their advertisement is stated, my lord. May I read, my lord?
Yeah.
Page 70, page 70. Second para, educational, master degree in chemistry from a recognized university or equivalent. Equivalent qualification to master degree in chemistry is master degree in organic chemistry or inorganic chemistry or physical chemistry or analytical chemistry.
They have already stated.
Stated in 2017, my lord.
That advertisement.
In this advertisement, you have not stated.
No, is it not stated? You are confined to the chemistry.
No, that's not say like that. Chemistry is a huge subject. It's a very huge subject.
But we are confined to the only this particular post. We have combined the essential qualification, education qualification, a bachelor degree in chemistry or master degree in chemistry. As he has possessed the analytical chemistry, this UPSC could not take into consideration and rejected.
It's wrong.
My lord, I am on behalf of the OP number 3 and 4 Union Public Service Commission, my lord. Only the person to decide, my lord, only lack of educational qualification. In my para 8 of the counter, there is educational qualification as per the advertisement, and we are, my lord, concerned with the advertisement dated 25 May 2024 for the Deputy Superintendent Archaeological Chemist. There is the contention of the petitioner that he has passed the analytical chemistry. There is no, and their challenge that in the 2007 advertisement, the petitioner was selected for the post of Assistant Archaeological Chemist. That was selected by the Staff Selection Commission. The examination was conducted. There was a word used equivalent. And they are challenging here why this advertisement, there is no such type of word equivalent. And it is very clear that is what is the educational qualification in para 8 of the counter affidavit, and also B, experience and desirable qualification. So analytical chemist is totally different. That is the master in chemist, sir. So she has no qualification, and the tribunal has rightly rejected her application, and that is due to lack of the educational qualification, and her application was rejected by the Union Public Service Commission. And my para, it is very clear, my lord, in counter affidavit para 11, 12, and 13 clearly shows what is their qualification and what is their contention, my lord.
There are no full stop, comma, etc. in your submission.
No, yes, sorry, my lord.
Where to connect verb, where to connect noun, we do not understand. We are taught commas, full stops, pauses. We have been taught in the school.
Sorry, my lord.
Now one sentence. You say one sentence, stop, then we process it, go to the next sentence. It is like music. No, we can't. The law does not sing music. It speaks through words, sentences. Yes. Now make one statement. We ignore everything you have stated, all irrelevant things. Now start one by one. Where is your advertisement?
Advertisement, my lord, in Annexure 1, page 12, my lord.
Read. Annexure 1, page 12.
Page 16, my lord. Essential. Page 16 of Annexure 1, my lord. Essential. Bachelor's degree in chemistry plus 3 years experience in the use of analytical instruments or methods of.
No, wait, Mr. Hall. Delhi. Are you from Delhi?
He's from Bhubaneswar.
My lord, Bhubaneswar.
Otherwise, we will be wasting our time.
No.
There will be difficulty. We tolerate all that. In matters is what you say we do not understand, what we say you do not understand. Then how it will take place? So you will fix a date, you come on that day.
Yes, ma'am.
In the meanwhile, there are 2 judgments of the apex court. where question of equivalence arises, how it should be determined. Our researcher is not here, otherwise you would have punished them. We will call this matter after vacation. Yeah, Mr. Haq, we request you to come here.
Yes, my lord.
Yes.
So actually, on the earlier,
After vacation.
only result only be published, my lord. Publication of the result, my lord.
No. Next.
38, 34957 of 2025.
Bring those two judgments which are in our favor
Yes.
to some extent.
38.
Item 30 on behalf of Ms. Kalpita Gadanath Mahil is appearing for the Chairman Central Board Treasurers. So today is some difficulties.
Okay.
So
Same
statement.
order.
Tomorrow.
With the request now. Next.
40, WTC 9722 of 2026.
May I please, my pardon, my applicants. It's that for OP number 3.
So it's appears for OP3. Call after vacation. It's already adjourned. Order is passed. Order is signed. It is signed so that next time you mention when it comes. Yes.
Item 40, WTC 9722
May I please, my lords? My lords, by the earlier order, your lordship was kind enough to direct me to deposit 3 lakhs in 2 installments, your lordship. That has been done.
What is the amount due?
My lords may kindly see page 30.
We will
It
not
was
see anything. What is the amount due?
My lords-
Answer the court's question.
My lords, 11 lakhs 92,102.62.
When it was borrowed.
My lords, this is a cash credit loan in which the limit is 9 lakhs 80,000.
Nine lakh?
80,000, your lordship.
That was in the year?
2022, your lordship. That is continuing.
6/4/2020.
6/4/22.
My lords. 22. No, it turned NPA in 24.
6/4/2022.
46, 4th of June 2022.
46.
My lords. Date of sanction.
Date is not correct. This. How much is due as of now?
My lords, the latest that I have is that Annexure 6, which is dated 7, is my lords, I'm sorry.
7/2.
No, my lords, the next paragraph, the last paragraph, which says above bank as on 22nd of February 2026, it is 11 lakhs 92,102.62.
How are you going to pay that?
My lords, what I was praying, your lordship, since this is a cash credit loan, if I am allowed to regularize the loan, means pay the extra amount above 9 lakhs 80,000. Thereafter, I continue my business and keep on paying the interest in whatever I manage that business and keep on paying the cash credit.
Is it permissible? Permissible. To do that. Huh?
I've paid an amount of 3 lakhs, your lordship.
3 lakhs pursuant to interim order.
Pursuant to the interim order of my lords.
Interim order dated?
That was 6th of April, your lordship. 6th of April 2026.
Only things I'd like to submit, it's required. The amount which has been disbursed not only cover this book outstanding or statement of account outstanding, but also he has to maintain stocks. Suppose we are giving 10 lakhs, 9 lakhs 80,000.
Because it's a cash credit loan.
Cash credit. We have to see, bank has to verify. So there is a provision. Every month he has to give a statement of account.
Correct.
No doubt he is account maintaining, but stock point of view, it's a what instruction I've got, it is very liberal. So whenever minority is pleased to pass some order, so kindly think he has to also simultaneously maintain the stock as required by the bank.
As has been maintained till now. Because that was, my lords may kindly appreciate, since 2022,
till this was, I was not able to pay the interest amount. When thereafter it was declared NPA, it was being managed smoothly. There is no.
Now they will lift the
Instruction, what
NPA,
I told I.
provided you maintain the stock register
My lords.
and furnish a copy of the same periodically to the bank. It's not a cash credit facility.
My lords.
In cash credit facility, Tannan on banking, he says you have to furnish the borrower, the facility availer has to furnish the stock register to the bank periodically. It is a kind of hypothecation actually.
Against stock.
Against the stock it is. It's a hypothecation because you will have the stock, they will have proof of the stock. That's all.
Here I have provided a collateral security of my residential house, which was supposed to be put to auction, and my lords were pleased to stay. That is there with the bank. It's not a case that I have not provided that. Collateral security is also there, your lord.
No.
That is different.
In cash credit facility, the rules, RBI rules provide this.
My lords.
In fact, Tannan on banking law, he mentions these things. Take down. The essential grievance of the petitioner borrower is against coercive proceedings of recovery. First off, he had availed the cash credit facility quantified in a sum of rupees 9.8 lakh on 4/6/2022. Thereafter, the availed amount of loans having not been regularly repaid, the said account came to be classified as NPA on
8/10/2024, your lordship.
8/10/2024. Which notice you are challenging?
The auction notice, your lordship.
13/4.
No, auction notice.
Auction notice.
4/3/25.
No, 27/2/2026, your lordship.
This was followed by the auction notice dated 27/2/2026 at Annexure 6, which mentioned
The last paragraph, your lordship.
In case 30.
The last paragraph.
11,92,102.62 as being the outstanding as on 22/2/2026.
26, your lordship.
First, next paragraph. We had granted an interim order on 6/4/2026, which reads as under. Next paragraph. Counsel for the petitioner submits, and the learned panel, kindly be seated. Learned senior panel counsel appearing for the bank does not dispute that in terms of the interim order, petitioner has remitted a sum of rupees 3 lakh as of now. First off, counsel for the petitioner submits that he would make good all outstanding amount for facilitating removal of NPA tag within.
My lords, in my understanding of, since the amount was around 2 lakh rupees, I have already paid 3. So this needs to be now regularized and permit me to be conducting.
Counsel for the petitioner submits. No. Now, already rupees 3 lakh having been remitted, the bank should consider lifting of the NPA tag in accordance with the extant RBI guidelines. First off. Next paragraph. At this stage, learned panel counsel appearing for the bank submits, and we agree, that there is an obligation on the part of a borrower claiming, availing cash credit loan to periodically supply the stock register to the bank, whether there is collateral security or not. First of all, we hasten to add that there is a collateral security, namely mortgage of the house property. Correct? In this case. First one. Justice of the case warrant, next one. Justice of the case warrants that the bank should appropriate the amount of rupees 3 lakh remitted by the petitioner to the loan account in question and take steps to remove the NPA tag, subject to petitioner periodically furnishing the stock register, copy of stock register to the bank, and also permitting the bank official to verify whether the stocks are maintained physically. First up. In view of the above, petition is, with the above observations, petition is disposed of. First up, it hardly needs to be stated that if the coercive proceedings pursuant to Annex 6 notice
That's not been materialized. We have not 1%. As in,
would bail into insignificance.
Urgent copy of my lords. Much obliged, your lord.
Please. We have many matters we have disposed of today. Nearly about 106 matters. We have to complete the draft. We have to sign the papers. So if you permit, we will raise. Yes, if you do not, then we will say.
Grateful, your lordship.
Many orders we have to sign. We have to prepare, finalize. All right? Yeah.